You're all live.
Thank you very much. Okay, good morning, everyone. It is, now roughly at least 9 o'clock, and so I resume the further hearings of this examination of the North Hertfordshire local plan. My name's Simon Barclay. I'm a planning inspector and a chartered town planner, and I've been appointed by the Secretary of State to hold this examination into the soundness of the plan. You should all have read my general guidance note, which sets out the purpose of the examination hearings and my role, etc. And you will no doubt have also read my special guidance note about the virtual hearings. And everyone should also have read the privacy notices on the examination webpage. I just want to emphasise, particularly for newcomers to these hearing sessions, a few general points really about the use of Zoom. So we won't be using the document sharing facility on Zoom, and please don't hold up any document or anything else in front of your camera, and please make sure that no one else appears on your camera either. If you haven't already done so, it'd be useful to clear your background of personal information, and if you prefer, Zoom does allow you to blur your background as well, but please don't share any personal information at all during the hearing, either yours or anyone else's. The chat and reaction facilities in Zoom, which you may or may not know about, but there are those facilities on Zoom there. Those aren't to be used under any circumstances, please, and anything that is posted in the chat will be ignored by me, and I won't be looking at it. If you've joined using Zoom but you don't want your face to appear on the screen, you can turn your camera off, that's fine. I've set out in my guidance note what you should do if you experience interference or any IT problems during the session. So if you have my note to hand, just in case, that might be useful. The bottom line is, if all else fails, please contact Mrs. St John Howe. Mrs. St John Howe won't generally be appearing on the screen throughout the sessions, but she will be observing the hearing sessions to help with any problems. So she is on hand to provide assistance whenever needed. Just in terms of the sort of procedure then for the hearing session, if I can I'm asking everyone to join with their microphone muted and their camera switched on. And the reason for having the camera switched on really is because I'd rather have some faces on the screen in front of me rather than be talking to a blank screen for 3 weeks. But as I have already mentioned, if you don't want your face to be visible, that's absolutely fine, and you can have your camera switched off if you prefer. So yeah, at the start of well, some of the sessions anyway, I'll check who's appearing. I am going to do that this morning because we do have some new people joining us. So I will shortly be taking a brief register and asking people to confirm that they are here. I'll then lead the discussion, introducing each topic in the normal sort of fashion, really. When I ask you a question or you come to speak, please unmute your microphone, and when you finish speaking again, please try and remember to make sure that your mic is switched off again. If you are, so I'll then sort of turn to the next person. I'll hear points then from anyone who's raised their hand. There is a hand raise facility in Zoom, which most of you have become accustomed over the last week, I think, to using. So if you want to speak, use the virtual hand raise facility rather than raising your own physical hand. I'm not sure if anyone's joined us actually using a telephone. I don't think so, but if anyone has, you can use the raise hand facility by pressing *9 on your keypad. And when you've raised your hand, said what you wanted to say, and I've moved on to somebody else, please could you remember to lower your hand again. When it's your turn, please make your contribution brief and focused and adhere to the agenda and the point or points being discussed at the time. You really don't need to repeat your full case in detail or give any sort of formal presentation. please bear in mind that I've read your representations and your hearing statements. I'll terminate the discussion on any particular topic when I consider that I've had enough information to reach my conclusions. And as we move towards the end of each topic or subtopic, I'll normally ask the council for their comments on the points raised if I haven't already done so before moving on. Yeah, as well as a break for lunch, I'll be taking short breaks during the hearings. And when the hearings adjourned for a short break, and I got this wrong last week, so I'll try and get it right this week. For the sort of morning and afternoon breaks, as it were, please turn off your camera and mute your microphone or your telephone if you've joined that way. That's quite important during those shorter breaks, because the live feed and the recording can't be stopped during those adjournments. So anything that you do or say will be live streamed, and if you don't turn your camera and mic off. During the break for lunch, it will be necessary for us to actually leave the meeting, is my understanding. If there's any change to that, I'll let you know at the time. If, yeah, please, when the hearing resumes after the break, please turn your camera back on, but keep your mic muted. So yeah, I probably ought to mention for those that are newcomers that I'll be using my Matters and Issues papers as the basis for our discussions, as we did at the previous hearings. I haven't prepared any separate agendas like that, so please do have my Matters and Issues paper in front of you. That will be helpful. And I should also mention that I'll be taking notes of the discussion as we go along. So just as in real life, you might find that my head is down quite a bit whilst you or indeed someone else is talking, because I do need to take my own notes of the discussion. I'll try my very best to multitask, and I'll try and keep eye contact as much as I can, but please don't be put off if you're talking and I'm looking down, or indeed if I'm looking up, because your faces are on a screen slightly above my eye line. So if I'm looking up rather than looking off vaguely into the middle distance, that actually means I am looking at you as you're speaking. So hopefully that's all reasonably clear and everyone knows what they're doing and how the hearings will be run. Are there any questions about what I've just said? If there are, if you could raise your virtual hand. Okay, that's good. I have no virtual hands raised, which I take to mean that everyone knows precisely what they're doing. So that's marvelous. Yeah, as we do have some new people joining us today, I'm going to ask everyone to do brief introductions, and for those of you that are new, it's a good opportunity to practice all the unmuting and remuting, etc., that I've just described. So I'll call your name in a school register style, and if you can just please unmute and say good morning, just to confirm that you're here, that will be great. Thank you. So for the council, then I have Ms. Hornsby.
Morning, sir.
Mr. Smith.
Good morning.
And Mr. Deanwood of Wood PLC.
Good morning.
Good morning. I then have for Ash Hill, Ms. Stocker of CBRE.
Good morning, sir.
I have Mr. Aspinall.
Good morning, everybody.
For Mr. Peter Barrow and others, I have Mr. Watts of Maze Planning.
Hi, hello everyone. Hello, sir.
Good morning. I have for Blore Homes, Mr. Williams.
Yes, good morning, sir.
And Mr. White of White Peak Planning.
Good morning, sir.
I don't know if that was you, Mr. White. I was getting quite a lot of sort of echoey feedback.
Let's try that again.
Oh, that's better. That's better. Okay. I have on my list to attend today Mr. Burrows, but I understand that he's not here. Are you not here, Mr. Burrows? I'll take the silence to mean that that he isn't. I have Ms. Cottier.
Good morning, thank you.
Good morning. On behalf of CPRE and also the parish councils of Codicot, Nebworth and Wymanley, I have Mr. Griffiths.
That's correct, sir. Good morning, everybody. Good morning, sir.
Good morning. I have, I can never pronounce this, Crudace. I never quite know how to say that. My apologies. Do I have Mr. Wilson of Barton Wilmore?
Hello, good morning. I'm here. It's Crowdays Homes.
Thank you. I will try to remember. Is that Mr. Dorman?
Yes, good morning, Mr. Inspector. Thank you very much.
Good morning. And for Gladman, I have Mr. Goatley.
Sir, good morning.
And I understand it, Mr. Goatley, that you're not going to be joined by Mr. Ball.
No, that's correct, sir. Mr. Ball is, I think, going to be watching in the wings, so to speak.
Thank you. I have Ms. Hamilton.
Inspector.
Morning, Ms. Hamilton. For Mr. Holford and others, I have Mr. Hutchinson of Hutchinson's Planning.
Morning, sir.
For Letchworth Garden City Heritage Foundation, Mr. Ames.
Good morning.
For Luton Borough Council, Mr. Bedford.
Morning, sir.
And Ms. Barker.
Good morning, sir.
And also representing Councillor Moles, I have Councillor Moles herself.
Good morning, sir, and everybody else. Thank you.
Good morning. And do I understand, Councillor Moles, that Councillor Wynne, who's also representing you, is going to be joining us later? Is that right?
Well, this afternoon, sir, he has other business this morning.
Sure. For New Road Ashbrook Limited, I have Mr. Bolton of DLP.
Correct, sir. Good morning.
And also Mr. Goodall as well.
No, it's just my good self, sir.
Okay, thank you for that, Mr. Bolton. Mr. Norgan is on my list, but I believe he's not with us as yet. Is that right? Mr. Norgan, are you there? I'll take it that he isn't. Do I have Ms. Pears? Okay, not as yet at least. Mr. Rigg.
Good morning, sir.
Good morning, Mr. Rigg. For Save Our Greenbelt, then I have Mr. Parkinson.
Good morning, sir.
And Mr. Hawkins.
Good morning, everyone, and good morning, Inspector.
Thank you. And I see. Also, on behalf of Save Rural Codicot, you get to introduce yourself again, Mr. Parkinson.
Good morning again, sir.
Thank you. For Save the World's First Garden City, I have Mr. Coates.
Morning.
And for Savills, on behalf of the Crown Estate, Mr. Dixon.
Good morning, sir.
For Transition Town Letchworth, Mr. Lovegrove.
Good morning.
And also Ms. Sunander.
Good morning.
Morning. Do I have Dr. Ween?
Yes, good morning, sir.
And Mr. Whale on behalf,
Yes, sir.
On behalf of Mr. Wilson.
Yes, sir. Good morning.
Thank you. Okay, is there anyone here who is present, but I haven't called out your name? Okay, very good. Right, thank you very much for that. Are there any questions or anything else then before we move to the matter for today and indeed tomorrow? Good, thank you. Sorry, did someone say something then? No, okay. In which case then I'll turn to matter 23, the Greenbelt review work and the site selection process, and issue 23.1. Yes, I'm just going to read this out actually, just to make sure that everyone knows what's what, and to make sure that that I understand things correctly as well. So yeah, I wrote to the council on the 9th of July last year, and the council replied. Part of its reply was what I'm calling paper B, because that's what it said at the head of it. So for my purposes, if anyone is referring to it, I know it's also got an examination document reference number, but I don't have that noted. But if you could refer to it as paper B, I'd be grateful. So paper B of the council's response to my letter explains how the council's assessments of the contribution of land parcels to the purposes of including land in the Greenbelt has been taken into account through the process of selecting sites for development. And as I understand it, this has been a two-stage process. Stage one being initial sift through the Strategic Housing Land Availability Assessment, the SHLAR, involving an assessment of the suitability of sites, including in relation to Greenbelt factors. And then stage two, having done that initial sift, assessing the contribution that areas and potential development sites make for the purposes of including land in the Greenbelt through the Greenbelt Review and the Greenbelt Review Update to help inform the judgment about the existence or otherwise of the exceptional circumstances necessary to warrant the release of the land in question from the Greenbelt. And paper B, the council's paper B also explains how the sustainability appraisal has considered matters relating to the contribution land parcels make to the purposes of including land in the Greenbelt. So question A, and I would say that all of the questions that I'm asking under this issue, that's issue 23.1, are about the approach that the council's taken. All of the questions under issue 23.2 are in effect about the outcomes, and I don't want to blur the two. So I do want to take it quite clearly in that sort of logical stage, in that sort of logical sequence. So question A, a nice simple one to open the session with then. All of those things that I've just explained, have I got that right? Have I understood the council's approach correctly? I don't know, I'm going to put that question to the council first of all. I don't know if that's one for you, is it Mr. Smith?
It can be, it's a one-word answer, yes you have, as we've put in our matter 23 statement.
Okay. Is anyone here to tell me that I have not understood that correctly? Well, that is a good start. Marvellous. In which case, then I will go to my second question, which I suspect might take a little longer. Is the approach that the council's taken reasonable, adequately robust, and consistent with national policy? I don't want to, yeah, okay. I'm not exactly going to take B and C together, but things might end up that way. Let us see, I think. Mr. Smith, first of all, you are, I'm sure, going to tell me the answer to that is also yes. But could you or someone else from the council give me some more explanation, please, and tell me why?
Yeah, certainly. Obviously, when we had the original hearings back in 2017, we went through kind of a lot of this in terms of consideration of the strategic housing land availability assessment and the Greenbelt review that we had there at the time. And following those hearings and sort of in response to some concerns raised there and in response to case law, we then went away and produced a Greenbelt review update, which I guess is sort of at the crux of today's session. And that update we consider obviously to be a robust analysis of Greenbelt matters. In particularly, it was updated in response to case law, which looked at how we should take into account the concept of openness when looking at Greenbelt matters. Now that's subsequently been slightly superseded by a Supreme Court case, which came to a slightly different conclusion. But you asked us for a note on that, which I think is ED 185, and I'm sure Ms. Ormsby will pick up on any precise legal points. But essentially, we've said, well, all the factors considered in the Greenbelt review update remain relevant and sound as a matter of planning judgment, even if we're not strictly required by law to do it. The Greenbelt review, in terms of its methodology, we took the opportunity to sort of review and update that methodology compared to how we did the Greenbelt review to make sure it was robust. Obviously, kind of widespread Greenbelt reviews by local planning authorities is a relatively recent development in plan making terms, and obviously there's an opportunity as others go through the process to learn from each other and learn from best practice. So there were some changes to the methodology in the update, and both the methodology and the findings were effectively peer reviewed by Wood, and Mr. Deanwood's here to comment on that if needed. Wood effectively acted as a kind of critical friends to the council in doing that work.
I think it might be helpful just to give a bit more detail. So first of all, yes, part of the purpose of the Greenbelt review update, if we can just call it the update, short. Yep. Part of the purpose was that, part of the purpose of that, as you say, was to make sure that the
You froze there, sir. I didn't catch that.
Oh, my apologies. Right. I don't know where you did hear. So
I think, sir, I think we got to the point where you said the purpose of, and then you froze.
Ah, right. Okay.
You might want to go back to that point in your notes.
Okay. Thank you. Right. So Greenbelt update, the update, part of the purpose of that, as you say, was to make sure that it fully embraced the concepts of openness and to ensure that it was compliant, if I can use that word, with case law as it stood at the time. Yeah, so I've got that right.
Yes, that's correct.
Okay, so let's just take that point first of all. Yeah, we point to the Supreme Court case that what it shifts that position slightly, does it?
I wonder whether it might be more helpful if I come in here rather than expect Mr. Smith to answer that question. Would that be helpful?
I was fully expecting.
Yeah. Okay. Thank you, sir. I mean, the position is as set out in ED 185 paragraph 6. Our position is that the Greenbelt review update, the update, is still wholly consistent with case law. Would it be helpful if I just set out my understanding of what the Supreme Court in Samuel Smith held? Would that be helpful to you, sir?
Very briefly.
Yeah. I think maybe a sort of a three-stage process. Firstly, obviously, sir, you'll be aware that in considering the effect of a specific proposed allocation in this plan, because that's what you're concerned with, the openness of the green belt is clearly something that one needs to focus on. And that obviously, as you know, so is the fundamental aim of keeping land permanently open. And the Supreme Court held that in considering that fundamental aim, that big point, there was no explicit or implicit requirement to consider the potential of the visual impact on the land to be allocated over and above the spatial impact on the land as a result of the allocation and its development. And the spatial impact essentially comprises the fact that you are pushing built development where there currently is none. That's the spatial impact. The Supreme Court went on to hold that the consideration of the differential between the potential visual impact of an allocation over and above the spatial impact is only required when it is obviously relevant on the facts of a particular case, and that is a matter of planning judgment, obviously subject to the test of irrationality. So as I understand it, the Greenbelt update looks at whether or not there is any visual impact over and above the spatial impact that needs to be taken into account as a matter of planning judgment. And the writers of the update concluded that it did in certain instances, and that is why, as I understand it, there has now been an uplift in relation to a number of the sites, that when you reach that planning judgment, in looking at whether or not there is a differential between the spatial impact and the visual impact, the conclusion in respect of those sites is yes, and it makes a difference. That's my, and so therefore the update, even though it was actually carried out in response to the Court of Appeal at the time, has done that, and therefore it's wholly compliant with what the Supreme Court has held is the appropriate approach. So I hope that's clear. If it's not, then please let me know, and I'll try and clarify further.
No, it is. I understand the point.
Thank you, sir.
Thank you. Yes, Mr. Smith. So yes, concept of openness was one element that went into the update. Was there anything else?
No, it was mainly, as you say, and as Ms. Ormsby says, in response to the concept of openness and making sure it was covered off. I think, as we said in the introduction to the update, we say the original Greenbelt review sort of did implicitly cover those matters in our view. There are kind of references to it, but they're not as clearly spelt out as kind of Greenbelt reviews that have been done sort of post those cases coming forward. So we kind of went back through and basically explicitly, and it's all in the appendices for the strategic parcels all the way down to the sites. There's a kind of specific description in each case about visual openness, physical openness, and our conclusions on how that impacts. And as Ms. Ormsby said, long story short, it resulted, yes, in an uplift to our assessment of the potential harm of some of the sites, and probably best to pause there, noting that you don't want to sort of blur into the outcomes at this stage.
And so if I can just sort of chip in there, I mean, obviously openness was taken into account in the first assessment, the first Greenbelt review. All we are talking about is the additional component of openness, which is the visual impact, insofar as there is a visual impact over and above the impact on the spatial element of openness. So the spatial element was always taken into account. It was unclear the extent to which any visual impact over and above that spatial impact was taken into account in the first review, and that was remedied in the update. So that, you know, we're talking about something really quite discrete and limited. It's not just the general concept of openness, it's that small element of it that the update made clear and led to the uplift in the sites that you've seen.
Okay, and undertaking that work, Mr. Smith, involved going out and seeing places, did it?
That's correct, yes. Both myself and the council's principal landscape officer, who's unfortunately unwell today, conducted those assessments. And as I say, we had Mr. Deanwood from Wood, who have conducted a number of Greenbelt reviews themselves, effectively acted as reviewer, critical friend of those assessments to make sure that, you know, in his expert view, the conclusions we were coming to were sort of consistent with the type of conclusions you see in other reports of this nature across the country.
So a peer review.
Yeah, effectively, I think that's the phrase we've used in our statement, I think.
Mr. Deanwood, is there anything useful that you could add?
Sorry, were you calling on me, sir?
Yes,
I didn't catch you. Okay, sorry. Yes. Well, just to add that there is actually no prescribed methodology for these Greenbelt studies, so they are evolving in their character through best practice and the introduction of notions of visual openness is just such a refinement, so it's quite reasonable to take that into account. And I think it introduces a helpful level of refinement to the study and its conclusions. And actually, the product of that is the uplift in some of the gradings of some of the parcels and sites which have resulted from that. So it shows that it's actually working in that respect. So I think it's a perfectly reasonable thing to do, and just shows that good practice does evolve and is helpful in that respect. And that subsequently then feeds into the council's decision making in respect of the likely effect of development on particular areas, sites.
So in your judgment then, Mr. Deanwood, you say, do you, that the council's approach has been one of good practice?
I would say so. I have been author and involved in the examination for Waverley, Stevenage, Cheltenham and Gloucester, Tewkesbury, Staffordshire Moorlands, all of which have taken a similar approach and have been found sound by the inspector in those cases and found to be helpful in their decision-making process.
Okay, thank you, Mr. Deanwood. Okay, I've got a number of hands up here. Mr. Aspinall is first.
Thank you, Mr. Barclay. This is perhaps the biggest opportunity that the council are going to get to give me an answer to all the questions that I've been asking for the last 3 years about the question of the assessment. I think it was said that these sites are really coming out of the process of the SLAR, which was done in 2016, and no doubt is completely and absolutely out of date by now. In the meantime, as I keep asking, but the council don't even mention it or talk about it, why haven't they done a HELA? Why haven't they undertaken each year a housing and economic land availability assessment? If they haven't done that, although they may have walked around the sites, they've done this by just picking a pin up and putting it down on the map, as against doing a thorough and absolute assessment. In my view, if they haven't done that, we're getting to the stage where they have really gone into the stage of default. Now, the question is also looking at the Greenbelt. just let me say to you, I do want an answer from the council on this. No, ignoring the question, an absolute answer as to why they haven't done a heller. It's as simple as that, why they haven't done a heller. Because we keep asking about it, but they just ignore the question. They just move on as if it's never asked. As far as the green belt is concerned, there's of course another area, which is the land beyond the green belt. And the villages are of course land beyond the green belt. The green belt is meant to surround the towns and to give a buffer to prevent urban spread. It's different in the villages. And the land beyond the green belt, although I see in the local plan, it keeps saying that this should be treated with restraint. Nevertheless, as far as the villages are concerned, it is a fact that it is not green belt. I want to know whether the council are taking that matter into consideration when they're looking at allocations. Thank you.
Thank you, Mr. Aspinall. Dr. Ween.
Thank you, sir. Yes, in relation to the council's site selection process, I would like to understand much more clearly the criteria that they used for selecting sites and how they weighted those criteria, because to my knowledge, we've never seen any sort of methodology for selecting sites that is in any way auditable or can be subjected to public scrutiny. To give you an example, I would have thought that for a large urban extension, criteria such as good transport arrangements, good integration with the associated town, indeed minimizing the use of greenbelt land might all be good criteria to use, and all ought to be assigned an appropriate weighting based on their relevant importance. And of course, any showstopper issues that would prevent or severely constrain development would be identified at that stage. And then a weighted score would be calculated for each potential site. In my experience, processes of this type are widely used when carrying out assessments because their objectivity can be audited to check for bias. And that's an important point. The council's response to your questions confirms that if such a process ever existed, it certainly took no account of the contribution made by the land to green belt purposes. If you look at ED 172, paragraph 40, it states, and I quote, "The fact that land may be judged as making a limited..."
Dr. Ween, my apologies. You said ED 172, paragraph 40. Can you just remind me what ED 172 is? I don't have all the document numbers filed away in my head, so I don't necessarily know which document.
It's paper B, sir. It's paper B, sir.
Paper B, okay, thank you.
Thank you very much. Yeah, it's just one sentence, but it's a critical one, and it says, "The fact that land may be judged as making a limited, moderate, or significant contribution to greenbelt purposes is not in itself an influence upon the outcomes of the appraisal process." In other words, this has not been taken into account. I mean, it could either mean that no objective site selection process was ever carried out, or it could mean that the process simply ignored the greenbelt as one of the criteria. Either way, this is a massive failure in the planning process and helps to explain some of the bizarre results that the process has produced. Because so far as I'm aware, no objective site selection process has ever been published for NHDC's local plan. Instead, when you challenged them, the council produced a list of criteria but did not reveal their methodology. So the soundness of their process cannot be audited or subjected to any form of public scrutiny. If I can give you one very simple example, paragraph 14 of ED 175, and I'm sorry, I don't actually know off the top of my head what the title of that one is either. Do you need to stop and check? Paragraph 14, ED 175, it's talking about the exceptional circumstances that the council is claiming for the release of greenbelt land for gypsy and traveller accommodation. And I choose this example simply because it's a very short and simple one and illustrates my point.
My apologies, that's me. ED 175, I believe, is paper E.
That's right, yeah.
So the 4 criteria that the council identified for their exceptional circumstances, the first one was the identified need. Now, funnily enough, all developments have an identified need. I don't know of any that don't. So this hardly counts as an exceptional circumstance, does it? The second one was the lack of 5-year land supply for the travelling community. Again, I don't think that's an exceptional circumstance either. And the third and the fourth were the personal circumstances of the families and the best interests of the children. And the fourth one was the protection of the characteristics of the gypsy way of life. And I'm sorry, I don't even understand what 3 and 4 are saying. Perhaps the council could explain at some point. But it seems to me that whilst these 4 points may provide a reason to make provision somewhere, they are not reasons that require provision to be made in the green belt, and they are definitely not exceptional circumstances as required by the NPPF. Again, it is notable that no weightings have been assigned to these 4 criteria, and none of the criteria actually address the need to minimise development on the green belt. And these, the same point applies with bigger sites as well. So if you take a look at the reason given by the council for locating BA1, the massive development to the north of Baldock on greenbelt land, 2 of them make claims about access to transport and integration with the rest of the town, but completely ignore the fact that BA1 will be largely isolated from the rest of the town by the massive severance created by the railway line and the Baldock bottleneck. Then a further 2 reasons make claims about master planning and infrastructure provision that could be made for any large site and are not specific to large sites located within the green belt. And finally, the council make the truly bizarre claim that they are minimising the impact on the green belt by building on the rolling open countryside near Baldock rather than the rolling open countryside further north. In other words, the reasons given by the council to justify building on greenbelt land range from the irrelevant to the ridiculous. In my view, the council's reasons for citing BA1 and other large developments on greenbelt land actually boil down to 3 simple facts. 1, the council has a housing quota to meet. 2, the simplest and cheapest way to deliver the quota is to allow development on large greenfield sites. And 3, most large greenfield sites are located in the green belt. In other words, the only exceptional circumstances that the council can actually offer is the need to build more houses. Thank you, sir.
Thank you, Dr. Ween. Wale.
Yes, thank you, sir. I want to come back to the Samuel Smith point, if I may, because this is where matters boil down to. The council in its Greenbelt Review update applied the Court of Appeal's judgment. That was then overturned. The council has not revisited its Greenbelt Review. As a matter of fact, it's not redone the exercise. And its position to you is effectively, oh, don't worry, sir, it doesn't change anything. That's a very unsatisfactory state of affairs. I mean, I did slightly smile, Riley, when Mr. Smith said that the Court of Appeal's decision had been, quote, slightly superseded. I think what he meant was overturned. And Mr. Wood says, well, he's undertaken good practice. And I don't cast any personal aspersions on him, but he was obviously applying the law as it stood at the time, and that's no longer the law. What the council ought to do, of course, is redo the exercise, because the relative positions of the proposed allocations may change if the council applies the law as it now stands, and it's simply, in my submission, not acceptable for you to be told, oh, don't worry, it really doesn't change anything, because it might. And so I would ask you to find it's not adequately robust. It's not reasonable, the approach that's been undertaken. That's my Samuel Smith point, sir. Thank you.
Is that, if I can just put a question to you on that, Mr. Whale, is that to say then that you think that it is wrong in law or as a matter of soundness for the council to consider the issue of visual impact over and above spatial impact, where such an impact would be over and above the spatial impact?
No, the two court positions were essentially the Court of Appeal saying you have to take this into account, and the Supreme Court saying that the matters you take into account in terms of openness are matters of planning judgment. And as I say, that the simple reality is that planning judgment has not been exercised since the Supreme Court's judgment. You're told in ED 185, really in a sentence, effectively that the work doesn't need to be redone. And I say you can't be satisfied with that.
So, yeah, I mean, there are two issues here, aren't there? One is a legal issue, and the other one, if you like, is a soundness one. Putting the legal, what you might consider the strictly legal point to one side, and you know, just to help everyone out, I have read the judgments. So, but in terms of the planning judgment to be made, do you say that it's wrong as a matter of planning judgment for the council to have considered visual impact where there is one over and above the spatial impact?
No, you can't say legally that that's a wrong approach.
No, I didn't say legally. I said as a matter of planning judgment.
Oh, I see. Well, same answer.
Mr. Parkinson.
Thank you, sir. I'm going to deal with the site selection process and the extent to which Greenbelt contribution factored into that. But I think it's probably easiest to do it by reference to the flow chart in paper B, because whilst I think the council says that the sort of two-stage approach you set out in your matters and issues is accurate, they sort of direct you to that as a belt and braces summary of the approach. And the way that we see it is there are sort of three key stages in that approach. There's the sites that make it into the SHLA in the first place, 2016 SHLA, which is the long list. Then there's the sites that pass through the SHLA, which is the short list. And then there's the sites that are allocated. So the winners, although that terminology might not be completely appropriate. And
a better way of putting it.
Sorry, so I missed what you said. What would be better?
I said I'm sure you can think of a better way of putting it than the winners.
Well, let's call it the outputs, to use neutral terminology. And so we say that all three of those stages were flawed. In terms of the long list, I'm not going to go into that because you have from 2017 our detailed concerns on that, which I'm not going to repeat. But in short, as you know, we say the long list wasn't long enough because the SHLA was out of date then, and even more so now. And also a sort of passive approach was taken to identifying potential sites, relying on those primarily that the council had been informed about, rather than, as the PPG even then required, an active identification of sites. So, but I'm going to focus really on the shortlist and the allocation.
Just as a point, not just to you, but to others, Mr. Parkinson. You know, even though it was a while ago, I haven't forgotten the discussions that we had about the SHLAR before. So I don't want to dwell on the adequacies or inadequacies, depending on which side of the fence you sit, in relation to the SHLAR.
So I'd completely anticipated that, and I wasn't going to say anything more on that for exactly that reason. But you then get to so you have the SHLAR, you have the sites that you've got. You then have to, looking at the flow chart, work out which make it onto the shortlist. So they have to be SHLAR free tick sites, suitable, achievable, and available. And here we say that the process took a wrong turn in terms of how greenbelt considerations were factored into the process. And in short, we say that in deciding whether a site was suitable, greenbelt considerations were not given appropriate weight. And there's two problems. The first is that non-greenbelt sites that did get into the SHLAR were found to be unsuitable based on considerations which, under the MPPF hierarchy of protection, would fall below the protection offered to the greenbelt. And it's an instructive exercise to scan down the list of non-greenbelt sites that were found to be unsuitable and look at the reasons why. And you'll see there amenity concerns, harm to designated wildlife sites, not being sufficiently integrated with the linear core of the village, harm to listed buildings, those sorts of things. Now, obviously, these are all valid planning considerations. But here we have a situation where we have sites that are being released that make a significant or moderate contribution to the greenbelt, which made it onto the shortlist, which carried on this journey on the flowchart, and sites which, for example, don't relate well to the linear core of the village outside of the greenbelt, which do not. And what we can't see, and what doesn't seem to have happened, is any attempt to compare and contrast the harm caused, and no attempt to balance the harms identified for the sites that don't progress on this journey for non-greenbelt reasons against the need for new housing. Instead, as the flowchart shows, non-greenbelt sites are removed from the process for non-greenbelt reasons before we get to the balanced planning judgments I'll come on to in a minute that are at the core of the process. So to take just one example, a site that's kicked out for amenity considerations.
Sorry, if you bear with me a moment.
Yep.
Sorry, Mr. Pugs, you're referring, I think, to sites rejected for non-greenbelt reasons, did you say?
Sites that are outside of the greenbelt that are found to be unsuitable for a wide range. And so I can give you the references, but like I say, if you sort of scan down, you'll see the point. That are non-greenbelt sites that are found to be unsuitable for considerations that, if I can put it like this, are sort of general planning balance considerations, amenity, don't relate to the linear core of the village, less than substantial harm to listed buildings, those sorts of things. They're kicked out, and on the flowchart, they're found to be unsuitable and the site's rejected. Whereas sites that make significant contribution to the greenbelt sail through the flowchart to the next stage. And that is a fundamental soundness wrong turn, because the council has presumed greenbelt is not a bar to progressing. And at that point, they should have said, ask the question, well, is not relating to the linear core of a village a bar to suitability, whereas sites that make significant contribution to greenbelt is not? And the reason why it's a problem is because if you take for example, there's a site that was nearby industrial development, and it was said there were amenity concerns. Because that site was kicked out, it didn't get onto what's at the core of this flowchart, which you can see, consideration of all alternatives and making a series of balanced planning judgments through iterative consideration. So there was no attempt to balance the need for housing, etc., against those general planning harms that were put forward as justification for removing a number of non-green belt sites. So that's the first issue at this point. Concerns and issues which are given equal or less protection in national policy have been withdrawn from the process and don't enter into that balanced planning judgment. The Greenbelt significant sites sail through. The second is it's not clear how the Greenbelt review informed the SHLA and therefore the sites that got onto the shortlist. Now, the Greenbelt review was published in July 2016. I don't have the exact date that the SHLA was published, but it's difficult to see how the Greenbelt review could have meaningfully influenced the SHLA. And the reason why this is important is because a number of Greenbelt sites were removed from the shortlist. So they were on the SHAR long list, but they were found to be unsuitable because of Greenbelt impacts, and therefore again didn't make it through to the balanced planning judgments, which I'll come on to in a minute. So some Greenbelt sites were kicked out of that stage, never to be seen again, whereas others progressed. And if the SHLA wasn't properly informed by the Greenbelt review, we can't be confident that the sites that were removed caused less harm to the Greenbelt than those that did progress. And so you have in paper B, it's table A, Greenbelt sites considered unsuitable by the SHLA. And there are a number of sites there, for example, adjoining Luton, in Baldock, and Hitchin, which were removed because of the impact on the Greenbelt. And it's not clear to what extent the Greenbelt review played a role in that judgment, whereas other sites in the growth villages, for example, sailed on through despite moderate and significant harm. If the SHLA wasn't informed by the Greenbelt review, that is an unfair and unbalanced comparison between sites, because it's not been, the sites aren't being compared against and their Greenbelt impacts judged against a properly informed Greenbelt review. And so the final stage then you're on the SHLA, you've made it through the short list, so you're found to be suitable, and I've told you my concerns with that. You then enter into the big box in the middle, which is a series of balanced planning judgments. And I'll try and avoid straying into question C, but I mean, obviously this is vitally important, because when you come to write your report, for each site, you'll have to set out the exceptional circumstances. And that requires balancing Greenbelt impact as against what's said to be the exceptional circumstances. And there's 2 points I want to make here. First is an evidential one, which is, where do we see these judgments? I appreciate that there are a number of documents that feed into it, the essay, the Greenbelt review, the SHLA, but is there somewhere a document that pulls this all together and for each site says, taking all of this into account, here's why we consider there are exceptional circumstances? because that's what you need. There's Appendix 6 to the essay, which no doubt we may come back to, which sets out the positive and negative effects arising from each site. But the council have made clear in paper B that this is just one part of the evidence base. It's not where the balance was undertaken. The closest we could find is Appendix 2 to the Housing and Greenbelt background paper, which is entitled Summary Site Selection Matrix, which is the sites that made it onto the shortlist, and then each has a sort of 3 or 4 line blurb explaining why it's allocated. So the first question is that it? And then secondly, even if it is it, that was written several years ago now. And if you look at the...
Apologies, do you have the document reference for Appendix 2?
It's HOU1, it's the housing background paper. I'll see if I can get the examination library reference. It is HOU1. That's the examination library reference. Yeah.
Thank you.
So first point, is that it? And then secondly, that was written several years ago now. And the trajectory, which is Appendix 3 of that paper, has changed. Because Appendix 2, which is the blurb, sits together with the trajectory at Appendix 3. And so I'm not going to stray into what we were discussing last week, but as you know, the housing trajectory and the timing of release is now put forward as the central exceptional circumstance, at least insofar as the Greenbelt, the Growth Village releases are concerned. And when that Appendix 2 site selection summary matrix was written, we were in a very different world where it was considered that the Growth Village sites were needed to meet the OAN. And to some extent, therefore, the need for the sites to meet the housing requirement was a given. That's obviously no longer the case. And rather, the justification for the Growth Village sites is the need to maintain a rolling 5-year housing land supply. Now, the blurb that you get for each site doesn't consider that in any detail at all. And to the extent that it does, it's based on a trajectory that's now out of date. And so I'll wrap up because I know you don't want a presentation, but if I can just illustrate that with one example. Appendix 3, so the out-of-date trajectory on which the housing background paper gave an explanation for why sites were allocated. To take one example, site WY1 in Wymondley. Back then, that was anticipated to start delivering in 2020 and deliver for 3 years before the strategic allocations started to ramp up and deliver significant numbers from 2023 onwards. That's no longer the case. WY1 is now to deliver in 2024-5 at the same time as strategic allocations. Which means that when you look at these balanced planning judgments, and we think that it's in that paper, they're based on an out-of-date trajectory. And the exceptional circumstances, which is trajectory related, isn't considered in that paper at all. And I know you've set the council homework on this point, but that homework's obviously vital because the exceptional circumstances that are now being put forward aren't assessed in writing anywhere. And to some extent, it's not really homework, it's the whole syllabus that's missing, because that's what you need when you come to write your report. WY1, the exceptional circumstances in light of housing requirement being below supply, the need for certainty of delivery, where's the judgment where that's set out? And we struggle to see it anywhere. So that's all I had to say.
Thank you, Mr. Parkinson. Is it going to be helpful, Ms. Ormsby, Mr. Smith, for the council to pick up on some of these points now, or should I turn? I have Mr. Bedford is next on the list of those that have indicated.
I think we should most certainly hear from Mr. Bedford first, so, and then we'll. I mean, I assume that there's lots more points to come, and it will probably be more helpful to you, sir, just to deal with them all in one go. Whatever's most convenient for you, sir. We're fairly relaxed about it.
Okay. Thank you for Mr. Bedford then.
Thank you, sir. Good morning. Clearly, I'm dealing here with your first element, which is approach, and not getting into any matters of outcomes or specific site choices. And so the way that we look at matters is, first of all, we consider and continue to consider that the original exercise in the Greenbelt Review was robust, provided a proportionate and adequate evidence base to justify the site selection process that informed the submission local plan. And so we reinforce that by noting that in the council's ED 161A, which is the Greenbelt update itself, at paragraphs 1.9 and 1.10, they specifically confirm that visual effects on openness were part of the Greenbelt assessment of the original study, both as regards parcels and sites. So we say you can conclude that the original study was a robust exercise that was fit for purpose. Secondly, and this in part I think may help you with the points that Mr. Parkinson was urging on you, neither the 2012 NPPF nor its associated PPG prescribes any particular method for how, when one's plan making, one should consider the exercise of any Greenbelt releases. There is simply the broad test of exceptional circumstances. And so we suggest that there is a very big role in this exercise for planning judgment, and a very small role for people telling you that you must do it this way, or you cannot do it that way, or if you do this, you are committing some error of either methodology or even more so law. So we would suggest you can be satisfied that, provided that the approach adopted by the council takes a structured approach, looks at the relevant factors, and applies its structured approach consistently, the sequence or order in which it does particular tasks is not a matter that would make it unsound because it does it one way rather than another. They're just different planning judgments that can be legitimately used in the exercise. So that's what we say about the original approach. It's obviously, from the council's point of view, then carried forward in the Greenbelt update. And so what we say about that exercise shortly is that it was an unnecessary exercise in the circumstances of this case, and it therefore doesn't need to be used to displace any of the sound conclusions that come out of the original exercise. And the reasons why we say it was an unnecessary exercise is it was prompted by the Court of Appeal decision in Samuel Smith, which actually wasn't a plan-making decision at all. It was a development management decision in relation to planning permission for a quarry extension. So you say you've read the case, so I don't need to labour the point, but it wasn't actually even dealing with plan making. And as has been outlined, it was reversed by the Supreme Court. But it's also unnecessary because, as I say, the council has confirmed already that it had looked at the visual attributes of openness as part of the original study. So we say that the exercise was unnecessary. And I say that the third point, which I'm certainly not getting into in these comments, is, as you will see from our statement, when you do then get on to outcomes, we do have some disagreements with the council. But I say the main point I'm making here is that you've been presented with robust evidence and there's no need or reason to revisit it. Thank you, sir.
Thank you, Mr. Bedford. Okay, Mr. Watts.
Thank you, sir. I wanted to adhere to the issue of the way in which the council's Greenbelt reviews have been undertaken from the outset, and particularly reinforced in the update in 2018. It seems to me, being a long-standing planning practitioner and managing a consultancy some years ago that undertook urban capacity studies for a number of local planning authorities, that the council should, at the time it undertook SLAs from 2015-16 onwards, should have asked consultancies independently to assess the potential of all their urban sites to try and find as many sites as possible before even considering Greenbelt allocations in the replacement local plan. It's all very well having a peer review, and I'm sure Robert Deanwood has done a really good job in giving them a peer review, but that peer review has come at the wrong time. It seems to me that there should have been an independent assessment within urban areas of how much potential there was before even bringing forward Greenbelt sites for potential allocation. I also think that in the latest 2018 update, there's an issue with weighting as well, not necessarily the one that was raised earlier by Andrew Parkinson, which was how much weight was given to the protection of the Greenbelt against other factors, but in terms of the way in which individual purposes of designation of a Greenbelt were weighted. So, for example, the fundamental aim of designating a Greenbelt is maintaining openness. Well, to my mind, that should have scored more highly than having particularly permanent boundaries, for example. Openness is the fundamental aim. You should have had a scoring system which would have weighted that. Now, that's critical to my clients' concerns about the allocation CD1, land south of Cowards Lane, at Codicot. There are many other issues around Codicot in terms of infrastructure deficit, but in terms of my clients' concerns about allocating CD1, openness and visual impact is clearly fundamental to the protection of that piece of land. And I find it difficult to accept that for example, the garden centre site in the Greenbelt at the other end of the high street in Codicott has been ascribed by the council as having a moderate contribution to Greenbelt, which is the same overall conclusion to CD1.
Okay.
So
I want to hold you there, Mr. Watts. Valid points to make, but I don't want to go currently into the.
No. I'm trying to talk about the weighting that hasn't been given to key aspects of a review of the Greenbelt in terms of the purposes of designation. I think they should have been given different scorings, different weightings, so that for each proposed site allocation in the Greenbelt, you as the inspector could have said, well, actually CD1, for example, its loss would have a much more fundamental impact on the Greenbelt than maybe the garden centre site, where there are buildings, there is a commercial use, there are hard standings, there's a long-standing history of cars and visitor parking. That has, in my view, a far more limited contribution to the Greenbelt than other sites around Codicott or elsewhere. Now, we share Save Our Greenbelt and Save Rural Codicott's objectives in terms of the broad approach to Greenbelt, but I'm here representing my clients, and we feel that CD1 has, in a sense, not been properly weighted or scored in either the initial assessment or the later 2018 one.
I know the temptation is to draw on examples, particularly those closest to one's heart. But for the purpose of looking at the question of approach, if we could stick to, I mean, sometimes it's helpful and instructive to have a bit of an example to sort of prove the point, if you like. But I don't want to dwell now on outcomes. We'll certainly be coming onto that in detail later. So for now, if I can just ask everyone to stick to the question about the approach and the methodology.
I suppose my fundamental point, sir, was that the council started off on the wrong foot. It should have undertaken some form of capacity study for its urban areas before even thinking about bringing forward Greenbelt sites, or at least having the evidence base to justify why it couldn't find those sites. And we've heard evidence earlier from Mr. Aspinall, who said that the council, to his knowledge, had never undertaken a housing and employment land study, which could, in a sense, form part of that assessment of capacity in the urban areas. They've left it to the SLA, which understandably is brought forward by developers who instinctively will want to develop on greenfield sites, and that's been said earlier. And I think the council started just from the wrong position and is now playing catch up. Thank you, sir.
Thank you. Ms. Sananda.
Yeah, good morning. I wanted to sort of bring up the approach of in the review of the Greenbelt. It's sort of focused on the safeguarding countryside. I'll put my video on. Sorry. Yeah, it's focused on safeguarding countryside from encroachment and re-looking at that because of the judgment. But it strikes me, in looking at it as a layperson and not into this as my day job, that separation of towns when they're close together and safeguarding countryside from encroachment are quite closely aligned in some ways. So actually you can look at sites and they say, well, you know, perhaps it's gone down on safeguarding countryside from encroachment because some more buildings happened perhaps across the board, you know, particularly to the north side of North Herts, where we're sort of looking across to Bedford, that the countryside sort of become less valuable because of other building work. But by not looking at the separation criteria in the review at the same time, that may have gone up to counterbalance the other one going down. So I'm just, you know, I'd sort of like to put the question, can you do a partial review and actually get the right result? Are we now left with a Greenbelt review that's not really very sound because it's only taken sort of one aspect into account when they may be interlinked? So I wanted to sort of just raise that question in people's mind, whether that was a safe thing to do. And in terms of eroding the Greenbelt as well, I suppose it's a layperson as well, I'm looking to see if you're going to take our Greenbelt away, is there enough Greenbelt left to be a Greenbelt? And, you know, that's quite, when towns are quite close to each other or close to villages, then actually what's left? And I presume that comes into the separation bit, which is really important. You know, that's how it would pick that up, that the separation would erode. So I'm just concerned that hasn't by being ignored in this review, we're not thinking about actually not only if we're going to lose this green belt, but actually whether we can even get an effective green belt back around some of these towns at the end of it. I mean, I haven't seen any papers yet describing where the green belt's going to be after all this is over, but one presumes in some places that they will try to put a new green belt in place that goes further out to give us some protection. And the question in my mind is, from the review, is it clear we're going to be able to do that everywhere where it's been eroded? So I think, and the other point I think I'd like to raise, when somebody said it was unnecessary to do the review, this planning process has been going on a long time. And while North Herts has sort of not been able to build, bordering counties have been building. So, you know, in terms of we're looking at population increases and things, population prediction changes, it doesn't seem unreasonable to go and have a little review of this area as well. So I would sort of disagree it was unnecessary. I think it's been an interesting review. That's my points.
Thank you. Mr. Griffiths.
Thank you, sir. It's just a few points that I'd like to make. I agree with the point that the SLA is the tail wagging the dog in all this, but we are where we are. We do have the SLA, we have the SMA at the very beginning of the process, and other things seem to have to fit with that. We're supposed to be in a plan-led system. I would advocate a planner-led system, because clearly it's not. But then we've come on to the business of the study itself. And from the point of view of CPRE, I think we have welcomed it because it does provide us with a more fine-grained approach into the green belt. And I do welcome that as somebody obviously who's had a 50-year involvement with the green belt in Hertfordshire, and one also as a consultant who has been involved in green belt studies of this type, including, I may add, Mr. Deanwood, the earlier one on Cheltenham, Tewkesbury and Gloucester with Mr. Baker. So we do welcome that. But I think the points that have been made about the weight that has been given to the green belt, you need to take on board. I think I'm also involved, as you know, in the Welwyn Hatfield local plan hearing sessions, and Welwyn Hatfield have indeed themselves commissioned a greenbelt review, which did give that more fine-grained approach. That went to the council, and the council, as you probably know, have now determined that the sites which have the highest degree of harm on the greenbelt should be removed. And those points have now been put to the inspector, and main modifications to the plan will be brought forward to be heard at hearing sessions in the new year, which will involve a proposition that the sites with the highest harm should be removed from the greenbelt. I wish we had had that debate in the open from North Herts Council. It's a very important point, I believe. Then we come on, of course, to the business, as Mr. Parkinson has said, about exceptional circumstances. We raised this point from CPRE in the statements and the discussions that we had on matters 3 and matters 7. But so I don't want to go on too much about that. But I think exceptional circumstances here in this case seem to me to be diminishing somewhat in the light of changing circumstances. And you will have heard the submissions that we made on matters 21 and 22. So I won't go into that. But what we were asking you to do, sir, is to have regard to those 2018 ONS projections. We're asking you to, that if the OAN actually is reduced, then there is a whole debate to be had on exceptional circumstances, whether exceptional circumstances will be there to the same extent as the council originally suggested when it submitted the local plan. And yes, sir, it is a matter of judgment. I'm afraid it's your judgment, sir. So we wish you well for the next few months. And then I think the Samuel Smith judgment, I think certainly is a good one in my view, because it does take a side. It keeps some of the legal arguments away from the picture. Now it does come down to judgment. And finally, sir, I think I've just mentioned the fact that government is reviewing everything. My parish council clients wish me to say that the standard methodology is under review, and it is likely that there will be more of an accent on the Midlands and the North, and therefore they are saying that perhaps we ought to delay the plan altogether. I'm not sure if I can get on board with that argument, but I think things are changing. I think it's this list of changing circumstances, Brexit, COVID, the economic position, that mean that, and it comes back to the point I was making last week, sir, about the precautionary principle, getting something that fits now, leading to an early review. That's all I want to say for now, sir. Thank you.
Thank you, Mr. Griffiths. I'm going to take now the morning break. So I make it, yeah, if I can just reiterate, don't leave the meeting now. If you please just make sure that your microphone and camera is switched off, so that we can't hear and see what you're doing during the break. I'm sure none of us want that. So it is now 10:28. I adjourn the hearing to resume at 11 o'clock. Thank you. Okay, it is now 11 o'clock, and so I resume the hearing. I'm not entirely sure if everyone is back. There are still quite a lot of cameras switched off. Right, okay. On the face of it, it appears that there might be one or two people that haven't returned or haven't at least switched their camera back on. But in any event, I'm going to continue. And that's to Ms. Cottier.
Thank you. So I want to look at paragraph 8 of PPG, and there's a reference for it, 3-008-2019-0722. And it says very clearly that the assessment, I'll read directly the sentence, this assessment needs to identify all sites and broad locations, brackets, regardless of the amount of development needed, close brackets, in order to provide a complete audit of available land. So this goes back to what other people have been saying so far, that there hasn't been a complete list provided at the outset. So Mr. Bedford said that there was no need to return and revisit this, and that the process so far has been robust and thorough, and that there is no such strict process outlined initially. And yet you have asked the question to discuss today, that you've understood it that the council has taken a two-stage process. And when you asked whether anybody agreed or if anybody disagreed with you, nobody came forward and said that you've misunderstood that it was a two-stage process. And the council themselves have agreed that was so. Yet the problem is that it is not a two-stage process that's required. It may be a two-stage process that they've undertaken, but it's a five-stage process, according to the PPG, gives us a very, very clear method for assessing and choosing land. And that also includes some of the 5-year housing land supply guidance, although that's also tackled elsewhere. But when it talks about the assessment of land availability, it gives us a 5-step methodology to follow. So we're having a discussion about this at the moment, and I do feel that this provides us a framework, or almost like a checklist, to go through from start to finish. And then we could, by undertaking that process, we could take what should have happened and measure it against what actually happened, and decide whether that part of the that step of the process was missed, or whether it was undertaken. And at the end of that, we would see what parts were missing, and then we would have to decide whether they can be patched up now, or whether these are such fundamental foundational flaws or deletions that they can never be patched up, and that the plan isn't sound. But the problem is now that we've progressed so far into this process of examination, and time is marching on. So we could be in a position where we are trying to build further on something that has fundamental foundations missing, because the registry of land at the outset is in, if you like, the digging of the foundations of a house. That it must be deep, and it must be thorough, and it must cover the whole basis that the later structure is going to stand on. And without that being present, you start putting your bricks and building up your walls with your bricks and your mortar. If you haven't dug deep foundations, the structure is going to crumble. Well, it will stand for a short period of time, and then the cracks will start to appear as you go to the later stages. And that's what is happening now, because if you like, there has been 5 stages outlined in that PPG, and they give a flow chart as well, and the method has stage 1, the identification of sites and broad locations, and then stage 2 is sites broad location assessment, and within those 2 initial stages there are many sub-stages. So what I think now would be a useful exercise is to go through it paragraph by paragraph and say, well, did this happen? No, it didn't. Well, then if it didn't happen and it was supposed to have happened, can it be done now? Just for example, we have I'll give you an example of how this has impacted everything. So in the plan, we've got SP8, and it says that 20%, the target is that 20% of the total development is supposed to be on previously developed land. However, as we all know, what's happened is 85% of development is on the green belt, and that means only 15% of development is on either brownfield or previously developed land. So we're already in contravention of that key policy, which is a problem. Now, they were well aware that there was a problem at the well, at least as far back as when they decided to commission a study into a new settlement. The council did this back in 2015, because they knew that they didn't, that they were struggling to find land. But at that point, had they have taken a proactive approach and done a thorough inventory of land available, they would have had a longer list as a resource to go and look at. But because that was missing at the outset, they resorted to the call for site proposals, which tended to come from the developers that were putting forward their greenbelt sites. And they didn't have anything with which to counterbalance that, because they hadn't done the work, basically. So this has affected everything thereafter. It's affected how much greenbelt land has to be put forward for serious development. And when they were asked to do the greenbelt review, it's also affected their options for available alternatives, were they to remove the sites that are offering significant contributions, as well as some of the other contentious villages and other contentious sites that we all know what they are by now. So overall, there's a structural flaw as far as I can see, and I think that's backed up with the PPG and what the NPPF says as well in its footnote 6, which I'm not going to talk about that now. I'm going to bring that into a later point. But the question now is, since this has happened, is the plan going to be, where do we go from here? So we can either address this point now. It should have been addressed a long time ago, but I can't see how we can move forward without perhaps addressing the holes that, and can they be addressed? I think it's possible if there is a will on, say, the council's side, as well as maybe some of the participants in this hearing, to build a registry of available land, which hasn't yet been done. And we've got, and that's not, I'm not saying that the SHLA isn't partway towards that, it is, but the very fact that the brownfield register was only put forward into this plan on the 2nd of January in 2018, when Nikki Hamilton asked for the brownfield register to be produced, and something was given. And I think around that time, Miss Cheryl Pearce also asked for the Greenbelt register. Those two documents only were presented at that point, but those two documents should have been part of the assessment and the inventory at the beginning. So the fact that they weren't produced until years later shows that the brownfield register wasn't added into the SHLA at all at the beginning, because it hadn't been compiled properly. And as far as I can see, to this day, it still hasn't been compiled properly. They have something, but it's not thorough. I think we need to do, I would suggest that everybody put their heads together at this stage and address this flaw. I don't think we should send the council away to do it on their own, because I think we have an idea of what thorough means, and they have an idea of what thorough means. And to make sure that we don't miss anything, I think we should all participate in it. And then it may become apparent that there are some viable alternatives that could be added in instead of the most contentious sites. And then the sites that are not particularly contentious could remain. And if that exercise was undertaken now, before the end of the examination, we effectively could arrive at the point of having a plan that is more or less satisfactory to everybody and less likely to be challenged down the line and eventually adopted. Whereas if we ignore and just carry on and just pretend that problem isn't there, I think it could end up in a big, huge failure or some damaging development.
Thank you, Ms. Cottier. Mr. Bolton.
Thank you, sir. Just to comment on a number of things that have been mentioned. Firstly, in terms of housing need, it was suggested this morning that if meeting unmet need wasn't an exceptional circumstance, and we've referred to the Compton Parish Council judgment v Guildford before, but in paragraph 72 of that it's quite helpful, because there it is set out that exceptional circumstances can include general housing need. And it goes on to state that exceptional circumstances can not only include meeting general housing needs, but can also include the other advantages of selected locations, and also can include, if you like, a sound distribution in terms of a sound strategy. So all those are capable of coming together to justify exceptional circumstances for both Greenbelt release in general, but also when we come to look at the individual sites.
My apologies, Mr. Bolton. You gave me a paragraph reference number there, which I didn't.
Paragraph 72, sir.
Thank you.
It's actually I referred to it in paragraph 215 of our submission on this matter on behalf of New Road.
Thank you.
And of course, a sound distribution can include, if you like, access or proximity to some of the larger settlements which provide, if you like, higher level services, etc. Moving on, references were made to the amended trajectory. And my only point there is that there have been objections to the amended trajectory, particularly looking at how some sites might actually deliver a lot quicker than are in that trajectory. And just taking that point a little further, we know that the Letwin report on delivery, when it looked at delivery of larger scale sites, actually does make the point that one of the ways of securing high levels of development is to have a range of sites, including small and medium sites. So that is something, if you like, that feeds into what could be regarded as an appropriate strategy in terms of considering exceptional circumstances for greenbelt release. The point has been made about the SLA and the update to the SLA. Clearly, these are, if you like, a point in time, but the SLA is not simply about the identification of sites. It's about the identification and determination of whether sites are deliverable. And that's quite important, which is why the guidance as it's now written does require local authorities to talk to and engage, if you like, with the developers, because at the end of the day, these are the people who will provide the new homes for people to live in. And therefore it is important to understand what they consider is deliverable. Ignoring that renders the plan, if you like, undeliverable and therefore unsound. And I note that people are calling for that to be updated. The problem with planning is we are always dealing with a situation that is moving. And it's interesting to note that the objectors are saying, with regard to the plan, there is a need to update the supply, but we would be saying, if you're doing that, you would also need to update the demand side and take into account the current policy, which would be the standard method, not what might be coming over the hill, if you like, with a different methodology, but actually what is here and now. And there seems to be an unwillingness to look at that, and certainly to look at the issues of affordability. And just staying with affordability, you, Mr. Griffiths, and I realise that me and him probably worked opposite each other on one of the Hertfordshire county structure plan examinations many years ago. But the precautionary principle is a difficult one when one considers it in planning, because it cannot mean not to do anything, i.e. no action or little action, because the no action or little action in terms of planning in itself has negative implications for sustainability, both in terms of population, their ability to afford shelter. It has a negative implication for transport, in that it can make people travel further to go to work and to access facilities. And therefore be very careful, if you like, if one is looking at adopting a precautionary principle on the basis, for example, one might be having an early review. What you don't want to be doing is having an early review and adjusting allocations in the plan, and only leaving, if you like, long-term sites in the plan, and then go for an early review, because what you're creating there, if you like, is a hole in the supply, where what is quite clearly an area of high demand for housing is left, if you like, bereft of suitable sites to come forward in the short term. Thank you, sir.
Okay, Mr. Lovegrove.
Hi, hello. Is my sound okay?
It is, Mr.
Oh,
Lovegrove.
great.
Yes.
I've just heard the word sustainability for the first word this morning. Excellent. In respect of your query 3 and the council's response to ED 172 section 42, the council states their sustainability appraisal has affected the choice of sites and took into account a number of factors, 5 to be precise. So you may well consider, they may well have considered them, but sir, they have deemed them totally irrelevant. If you go through them, and there are only 5 points, we should not be building on significant greenbelt land when there is alternative. Secondly, none of the large greenfield site developments apart from Bordock could be described as sustainable sites, because whoever lives in these houses are going to need 1.5 cars per household, etc. They even mention motor vehicles in this particular point, and yet they're quite happy to lay down rules which imply that they have to be that far from services and facilities, which is their third point. They say they considered services and facilities, but they then ignore the fact they're going to be a car drive's distance from them. Their fourth point, they talk about affordable houses. These houses in the larger greenbelt estates are not likely to be affordable. The developers will be trying to minimize the percentage they have to build of affordable or social housing. And a fifth point, and it's TTL's Transition Town Lecturer's view, that these sites do not promote sustainable living, unquote. Now, in addition to those 5 points, they haven't taken into account a number of other sustainability aspects and indeed opportunities. There are sustainability opportunities in all this. And I'd just like to run through 4 of them. There's been the change of use legislation. Secondly, the shrinking size of town centres and windfall opportunities, closing shops, offices, industrial sites due to Brexit, COVID-19, increasing use of online shopping, the present economic recession, etc., all takes this into or should influence these choice of sites. And in fact, it was on Radio 4 this morning. I don't know whether you were listening to the Today programme, 8 o'clock this morning, but in the demise of Debenhams, it was stated that, let me get my words right, this will reduce the state of our town centres to the post-war 1950 to the state before the 1950 retail boom, i.e. before we had supermarkets and so forth. So these town centres are going to reduce. They have not taken this into account. A third point I'd like to make that they haven't taken into account is developments coming up to the north between Oxford and Cambridge along the corridor, a new station at Thamesford, for example, and people wanting to move there rather than in North Hertfordshire, where they again have totally ignored the fact that there's nothing in LTP1, the local transport plan, to solve the bottlenecks on the Welling Viaduct and the A1M to facilitate transport between all these people that are going to buy these houses, which will be generally commuters from the south, through these bottlenecks. Indeed, since 2018, from Letchworth, it now takes 45 minutes on average to get a train to King's Cross, whereas before 2016, before they changed the timescales, it took 30 minutes. Now there are some trains that do it in 30 minutes, but most of them are 45, and even then, you're less likely to get a seat. This is how bad the transport situation in North Hertfordshire has become. They promise an A1M upgrade to smart, but what we really want on the A1M is 3 lanes south and 4 lanes north up the Welling Hill. So all these factors that I've mentioned, which you've taken into account, would direct the council to go to alternative sites. They had the opportunity to do so recently on the 8th of October, but they chose not to do so. And I'm wondering whether the council isn't in sustainability denial. TTL recently asked a freedom of information question of the council. Will the new houses built on the council estates in amongst all the local plan, will they be built to zero carbon standards? And the answer wasn't, oh, we'd love them to be, we wish, maybe, hopefully. The answer was just a categoric, no, they won't be. That's how green our council is looking. We're amazed at how soon the developers were involved in this process, which is another bugbear to all this. They've enabled these developers to get these estates penciled into the land banks, and this has been to the detriment of council flexibility in making their more recent decisions. And this is illustrated by the fact they had to go into secret session during their key meeting recently. So, sir, please consider getting the council to go back to the drawing board and put sustainability at the top of their list of priorities. Thank you.
Thank you, Mr. Lovegrove. Yeah, just a reminder to everyone. Yes, town and country planning is quite complicated in that almost every one single aspect of it is in some way linked to almost every other single aspect of it. I would, though, ask people to try and stick to the questions that I've asked. I rather hope that with other issues that I have already covered those one way or another in previous hearing sessions. And just to remind everyone, we're on matter 23.1b, which is about, look, it's about the Greenbelt review work and the site selection process, but the focus here really is on the Greenbelt work that the council's done and how that has informed site selection. And the specific question is the approach that the council has taken in relation to the Greenbelt review work and how that work relates to site selection been reasonable, adequately robust and consistent with national policy. So yes, Mr. Goatley, if I could ask you to confine yourself accordingly. Mr. Goatley.
So thank you, and yes, I will confine myself accordingly as you wish. Indeed, I think my submissions to you can be fairly succinctly expressed. With regard to the issue of approach, because it's the issue of approach with which you are here concerned, I would broadly endorse the comments that Mr. Bedford has already made to you. So I'm not proposing to repeat what he has said. But the essential criticism that's made by objectors is that there are other ways of undertaking both the Greenbelt review and the site selection process. Now, as Mr. Bedford has reiterated and reinforced, neither the NPPF nor the PPG, nor for that matter any other national guidance, lays down a specific methodology for undertaking these exercises. So you've heard a number of criticisms made. Those criticisms are not by reference to a specific methodology which is advanced by government. Now, given the subject matter that we're dealing with, inevitably, there are a broad range of factors that have to be taken into account. And we would strongly suggest to you that these are not processes which are suited to a simply rigid or mechanistic approach. Now, paper B produced by the council has highlighted the processes which the council has adopted and which we would suggest to you are sound. The council has explained why some of the sites were not taken forward, as they were judged as less sustainable and less sustainable as locations for development. Or, for instance, they would give rise to other planning harms, such as a disproportionate level of housing in a single village. Now, that is an approach which resists the mechanistic, but is structured and considers both the contribution to the Greenbelt and other relevant factors, including the role and capacity of individual settlements and associated infrastructure. Now, those are matters which inexorably, we would say, engage planning judgment. Not some palm tree judgment, but judgments which are made explicit within the evidence base and are to this extent summarised in Appendix B of the Council's document HOU1.
You're me, Mr. Goatley. That's a phrase I haven't come across before.
Which one was that, sir?
The reference to the palm tree.
The idea of palm tree justice being one which effectively is handed out in a somewhat arbitrary or capricious manner by someone who perhaps has had too much rum and too much sun and therefore doesn't feel necessarily inclined to balance matters in the judicious manner, which I'm sure you will, sir.
Okay, thanks.
So it may be that the objectors who you've heard from would carry out the exercise differently to the council, and there may be benefits and disbenefits from whatever they advocate. And indeed, that could well be an interesting discussion for a different forum. But none of those propositions, however intricate or however superficially attractively they're expressed, indicate any absence, in my view, of soundness on the part of the exercises undertaken by the council. So coming back to your simple question, albeit with many complex attributes, is the approach which has been adopted by the council to these issues one which can be characterised as sound? In our respectful view, it is.
Thank you.
Thank you, sir.
Thank you, Mr. Goatley, and also for my apologies, bear with me. Okay, thank you for that. Ms. Hamilton.
I'd just like to quickly respond to Mr. Bolton and Mr. Goatley in regards to Mr. Bolton, who provided you with something regarding exceptional circumstances. You know, no matter what comes up in some of these legal hearings that we've seen and appeals and everything that everyone seems to keep harping back onto, you know, the MPPF was put in for a reason. And in response to what Mr. Bolton said, you know, you can't get around it. You know, 135 stated new greenbelt should only be established in exceptional circumstances for like a large scale development, and like proposals should show how the greenbelt would meet the other objectives of the framework, which we haven't done with the compensatory greenbelt that's been put forward. And it also states that, and the major crux is here, which I think a lot of the against have brought out, is before concluding that exceptional circumstances exist to justify changes to greenbelt boundaries, the authority must have demonstrated all other reasonable options, proactiveness on everything before doing so. And we can't go away from that fact. That's in black and white, you know, and no matter what has come up in these hearings, you know, it wasn't that long ago where our own government has stated it needs to continue to be protected. So that's in relying to that. And in response to Mr. Goatley, who said, like, it, you know, they've done their process, it's all cut and dry, it's all reasonable and robust and everything else. Some of the sites, some of the allegations, the sustainability is questioned. There is sustainability issues with some of the sites. So I'm now going to go through quickly what I've written down. I've sort of done it in an order. I do believe that it all sort of relates to your question, Inspector. If I do slightly do one point that's slightly off, I do apologise now, but I will do it as quick as possible. Okay, no, we don't think it's reasonable and robust. Number 4 in the general principles in their response to you stated it's clear they cannot meet their development needs. But as we've already highlighted, if lower variance were used for calculations or the OEM was reduced in line with the 2018 ONS, then they would be able to meet their need for housing at the end of the day, but not using these contentious sites. Okay. It also mentions in their response about the matter 7 and was mentioned that meeting with requirements of the MPPF The proposed new greenbelt disallows two of the key purposes. And in section 8, in their matter 7, it states the proposed greenbelt needs to promote healthy communities by protecting land as a countryside resource accessible to a large number of urban residents. So no matter what hearings we've got, at the end of the day, this establishes this huge amount on greenbelt, which is what we've all got a problem with, is your in section 8 it says, you know, protect land as a countryside resource accessible to a large number of urban residents. How is removing all this greenbelt east of Luton, north of Stevenage, like actually doing that? You're actually removing it from those urban residents that are using it. How is ignoring the GBRU and not allowing it to properly impact on these allocations, adhering to the MPPF and have a robust process? I support points raised by Ms Cottier in regards to the SPA and 20% being built on previously developed land. That questions the 84%. It's not a great calculation. The government's own guidance, again, PPG from 2014, states the assessment should reflect policies in footnote 6, and paragraph 7 states, and it's important to involve communities, which North Herts District Council didn't do. We've already gone into that before. So we didn't even agree that there was exceptional circumstances in the first instance to remove all of this greenbelt. And now the 2018 results, they don't seem to have had any impact whatsoever on that either. Okay, so we already knew there was a lot of contentious issues regarding the greenbelt. The council knew it, which is why the full council posed a resolution in February 2015 to look into a settlement, which would have alleviated that. You know, we're questioning the process here, and even though they knew about the contentious issues of greenbelts, okay, there was a call for sites in 2014-15, 4 years into the plan period. They had they already knew, it was already aware of. So why leave it 4 years into the plan period to call for sites? Again, this questions the process and the five-stage process in the government guidance, because it doesn't seem to have been adhered to for safety's sake. I've got just 2 more points to make. In ED 161A, number 10 stated, as with reconsidering the numbers, opportunity was taken to critically reappraise all sites from SLARs, planning constraints highlighted, and where unresolvable, sites considered unsuitable. But this doesn't seem to be the case, that this step was taken after the GBRU, which was done in September 2018. And this you can see highlighted in particular with one of the strategic sites. In number 6 of paper B, it says best approach on a site-by-site basis and informed by the judgment of the harms and benefits in a broader context. The site already ticked, the site I'm talking about, already ticked significant contribution in relation to 2 of the key important purposes. Okay, expert advice to the council from people that have been involved with this expert advice for 30 years, stated in the submission, we cannot see how this particular site could possibly be considered a deliverable site. That came into the council before the Greenbelt Review update. With that in mind, how has the process been classed as reasonable and robust when you've got certain sites where experienced people have said there's a question of deliverability with this? They've then had a Greenbelt Review update, and it's like this reappraisal, this critically reassessing process has then not happened afterwards, which surely it should have. Going on to number 22, it stated all sites still allocated in the Greenbelt met 3 of the criteria. This is also questionable in regards to this particular site, in regards to offering a substantial contribution, within the 5-year plan, and social infrastructure, both which are highly questionable. I won't go into it now, but I'm saying it because in their response to you under part A and B, this site was particularly mentioned. So that's why I'm addressing this now. My last point is, why, when the GBRU was completed, why were allocated sites offering a significant contribution not critically reassessed 2 years ago and taken into account any other contentious issues with each site that was raised over the last number of years? And then possibly, as there may have been a shortfall, unless they actually adhered it to the 2018 ONS, then we considered other sites within HOU 9, the 2016 SHLA, which hasn't been brought forward, such as 209E, which offers a lower contribution to the Greenbelt, but could have delivered 285 homes and might not be in the long run now so contentious. There are other sites similar to this that did tick the suitable, available and achievable boxes, but haven't been readdressed since the 2018 ONS and the Greenbelt Review update. And this is pretty important, so thank you.
Thank you. Mr. Parkinson.
Thank you, sir. I just wanted to pick up on some of the points made by Mr. Bedford, Mr. Goatley and Mr. Bolton in response to what I said this morning. Just 3 short points. The first is, it said that, well, there's no prescribed method in policy or law to determine whether exceptional circumstances exist. And that's obviously correct. And it's also said that this is a matter of planning judgment, and that's obviously correct. But so the points made regarding the weighting given to Greenbelt considerations as opposed to non-Greenbelt considerations when deciding whether a site is suitable or not, and therefore whether it's assessed further, and the fact that the justification for exceptional circumstances is out of date are key to the planning judgment that's ultimately yours of whether the plan is sound and is consistent with national planning policy. In other words, we keep on hearing, well, this or that is planning judgment, as if that's an answer to the points made. Yes, the council's made judgments, but you're here to review those planning judgments in the context of the soundness tests, one of which is consistency with national planning policy. You're not some sort of detached observer who only gets involved if the council's made a legal error in approach. And to pick up on Mr. Goatley's point, we're not saying the plan's unsound because another method should have been adopted. We're saying that the method that was adopted is flawed because it doesn't reflect national planning policy and the hierarchy of protections it sets out and is out of date. And those are plainly soundness points for you. And simply saying, well, their planning judgment doesn't really begin to engage with them. And second, and linked to that, for the purposes of what I said this morning, at least, we don't make any criticism of the Greenbelt impact judgments reached by the council. There's no Sam Smith point in what I said. Rather, it relates to how those judgments have then been factored in or not to the overall site selection process. And so the final point relates to what Mr. Bolton said about Compton. Yes, we accept, I think we have always accepted that exceptional circumstances can include meeting general housing needs. But so the point obviously here is that the housing requirement is below the supply. So the need has been met, and the exceptional circumstances, so far as the growth villages are concerned, relates to the need to maintain a rolling 5-year supply. And as I've said, that's a change in circumstance insofar as the justification for exceptional circumstances and isn't reflected in the evidence base. And then finally, Mr. Bolton mentioned that having a sound spatial distribution strategy can amount to an exceptional circumstance too. And yes, it can, but that's not the council's justification insofar as the growth villages are concerned. They were all justified on the basis of meeting the OAN originally, and now on the need to ensure a buffer above the OAN. It's not said that in any event, regardless of this, they're needed to ensure a sound distribution strategy. And so you only need to look at, it's paragraph 5.56 of the housing background paper. Justification for releasing the growth villages is on the basis that they make, and I quote, a substantial contribution towards meeting the council's ability to meet its housing requirement in full. That's it. So the plan and the justification Mr. Bolton's putting forward isn't the plan that you have in front of you. So that's it in terms of those points.
Thank you, Mr. Parkinson. Mr. Coates.
Sorry, getting there. Okay. This seems an absurdly simple point in the context of this morning's discussion, but the site selection, the changes in the size of the OAN has a direct impact on site selection. Now, the OAN has been cut by 6%. So, which of the green belt sites does the council propose to eliminate? Is it significant? Council say no. I think 800 to 900 houses, which is about the 6%, is very significant, especially for, say, the inhabitants of the village of Gravely, maybe for the village of Cockenhoe, maybe for the residents of the Grange Estate in Letchworth, which the council going to eliminate. NS1, LG1, maybe an east of Luton site. You see, this is a golden opportunity. Now, if the council's general view is that, oh dear, we've got to build on the green belt because we have no choice. If we did have a choice, obviously we wouldn't be doing it. You do have a choice now. Now, this is a straightforward planning decision. No delay is necessary. Just strike it out. Or does the council have some sort of attitudinal problem with this? If you don't strike out a site on the basis of 800 to 900 houses, I think you've got a problem with the sectional circumstances. It beats me how you justify not doing so. That's all. Thanks.
Thank you, Mr. Coates. Ms. Cottier.
Thank you. I think about reasonable as being the most common sense direct approach, using what's available before you. I did try to find what is the definition of reasonable, and I had overheard a lecture the other day about reasonable force in social care, and the lecturer was talking about the legal definition of reasonable, and they said there was no definition as such of reasonable. However, we tend to go think about as a general idea what the average most obvious answer would be to the average person on the street, as a common sense practical approach, a pragmatic approach. And reasonable alternatives for me would obviously have to start with that which has already occurred and is there for the taking, and that would obviously be developments that have already been delivered but yet were somehow not factored in when either the numbers were set or the allocations were made in various plans. At any location within the councils that are involved in these housing market areas allocations. So that might be Luton, it might be Central Beds, it might be Aylesbury Vale, or it might be Hertfordshire, North Hertfordshire itself. So what are the reasonable alternatives within those areas for meeting the needs overall? Because after all, they calculated the numbers that they're trying to satiate overall. So the same should apply when meeting those needs. They should be, maybe there would need to be adjustments made. I had suggested before, perhaps it shouldn't be Hertfordshire, North Herts helping Luton's need. It should be Luton helping Hertfordshire, or it could be Central Beds helping Hertfordshire help Luton, or it could be Luton doesn't have an unmet need. I've argued that point strongly, that it doesn't have an unmet need, because I've calculated how many houses that were outside of the plan allocation have been delivered in this year alone, and they are in excess of the unmet need. So talking about a need that doesn't exist is one thing, but if they insist that it does exist, I would say, well, let's look at what's possibly out there that we could use as reasonable alternatives. And if they are saying, well, we have to use the green belt because we haven't got enough land that's brownfield to match up to the number of houses we need, I might say, well, are you sure that's the case? Have you looked at what else is going on? After all, you do have a statement of common ground with the other councils saying that you're going to address these things together. So I looked up the other day the statement of common ground that was on the Central Beds site, and it was dated July 2020. And this statement of common ground was agreed between 3 councils. So one was North Hertfordshire, obviously, and then Central Beds and Luton. However, I noticed that Aylesbury Vale was not included, yet Aylesbury Vale is part of the total housing market area. So where is the 4th council in this? Why has it been suddenly omitted? Well, suddenly omitted since the beginning, really, because I began to then seek out if North Hertfordshire had some type of statement of common ground with Aylesbury Vale, and they had in document ED6, but it had been redacted. So have they been removed from the housing market area now? So we can no longer consider them as being involved. I looked up at Aylesbury Vale local plan, and it did seem to suggest that they had considered that another housing market area was where they best belonged. But I don't see that reflected in this plan, and I don't see that reflected in Luton's local plan. So if they're involved, then they should be considered in, they should be also in the statement of common ground. So, but anyway, this statement of common ground, it talks about these housing projections that the councils hold to be true, which I spent a long time debating last OAN session, so we don't need to go there again. We all know the views on that. But what I did notice was that they have numerous alternatives in the Central Beds plans, which we discussed some of them in previous sessions. But what's really interesting is that there are several mentioned, well, in the actual, specifically for Luton's unmet need, which is what of course affects one of the strategic locations that North Herts is considering, is that the new villages and new settlement options were clearly listed here, and they were really very large. And in total, even though they are for Luton's homes, they deliver in excess of what Luton needs in totality. Therefore, there's a residue. So why would that not be something that North Herts could use to help address its delivery via the new settlement that it had already taken decision at the full council meeting to look into, and they commissioned the Atlas study. And the Atlas study was part of the plan's development process. It was featuring right at the start, and it was undertaken and commissioned, and it was particularly because of the Greenbelt contention, that the contention over the Greenbelt sites, that the decision was made by the full council to commission this study. So they had Atlas. They took the, as Miss Hamilton also mentioned this, she said that the decision was taken by full council to look into this because so many people were upset about the number of houses being delivered on the Greenbelt. So they went ahead and they did commission it. And I think they spent a year or so looking into it, but this doesn't appear in the examination library as far as I'm concerned. However, in Central Beds, for example, Marsden Valley is a new settlement. It's a new village of 5,000 homes. So would that be a new settlement that fits the definition? So whilst the councils were working together, all three of them, alongside one another, there was acceptance that as a reasonable alternative, a new settlement could be looked at, and that was something that the NPPF also encourages. They went ahead and began to look at the viability of that. Meanwhile, alongside that, Central Beds was indeed also looking at possible sites for a new settlement, and they have found them and they have listed them in the plan. And then the new settlement options were given as option 1 or 2. One was in exam document for Central Beds 113. It's got a housing technical paper that was made this year. The two options, option 1, new settlement, was a village scale one, which was 1,500 to 5,000 homes. And the option 2 was a large town scale new settlement, which was more than 5,000 homes. So that would match the definition of the new settlement approach that the council had started way back in 2014, carried into 2016, had actually created an urban development corporation through which to deliver such an urban settlement. I presume it was based on the advice in the Atlas study, where they said that as Ebbsfleet had delivered many of their new settlements via urban corporation vehicles, this could be done. And everything looked set to kind of go ahead. And if the Central Bed settlement sites were not reasonable alternatives, there were, of course, the other options of the well-known sites for this, which one was between Ashwell Station and Royston. That was always the site that was possibly good for a new settlement. But there was also some other land which is slightly smaller. Between Baldock and Royston. That was on the rail line to Ashwell. That was the first well-known site. And then there was also a fair-sized site near Buntingford, although that's smaller. But there was also a site that Mr. Parkinson brought back in the original hearings, which was a site called Rush Green, which had been identified. That was in OLP3 document on page 26, which was a thousand dwelling settlement. But these all disappeared into the mist and didn't get followed up. So they weren't exactly written out. They were just sort of pigeonholed for a while, but nobody actually put in writing, this is over, we're not considering a new settlement anymore because X, Y, and Z. They just simply didn't mention it for a very, very long time. So there's no reason why this can't re-emerge and become a reasonable alternative, especially if the reasonable alternative is matching, is only, the need to find a reasonable alternative is only there because of the need to demonstrate the need to satisfy the claimed exceptional circumstances, which in turn is based on housing numbers, which is in turn based upon buffers that are at this point unclear, then if something is unclear and uncertain and a little bit down the road in terms of time, new settlement matches that very perfectly. It's down the line. There's options surrounding it. It does not even have to be in one location. And this was something that I discussed directly with Councillor Levitt in the very first sessions in the break. We had an interesting conversation about about the concept of new garden cities. And I told Councillor Levitt an interesting story. I said, when I lived in the Far East, I noticed that there was a different approach to how large things could be broken down into smaller parts. For example, you would have, say, like a pop group where normally they would all work together and they'd be very, very popular. And everybody would say, we know this pop group, but they had in their contracts written that they could work as individuals as well, but that didn't breach the identity of the overall pop group. So I said to him, in terms of this idea of a new garden city, why does a new garden city have to be in only one location? Why can't it be sort of like interlinked nodes, an overall concept that can be intertwined and popping and placed in various locations, but the common link is certain garden city principles that they all carry out. And I spoke about this to somebody and they said, that's really interesting because that's exactly the approach that the Gilson Villages has taken in East Herts. They've got the idea of garden city, but they've spread it out in multiple places. It doesn't have to only be in one massive location. Say you had like 3 fairly large locations that were in different places, they could be essentially conceptually a new garden settlement and following principles as almost like brand identity. So I just thought that was just an interesting thought, that we seem to be kind of limiting ourselves and being maybe trying to not adapt. There's lots of options available, especially if numbers are not 100% certain. And that's what was, I think we could be more imaginative in our approach. I know we have to be solid and fixed to a degree, but to the point where it becomes oppressive and, you know, we're saying, you know, we're questioning the local plans approach. Was it robust? Was it sound? Well, maybe it was in parts, but it wasn't in other parts. So can't we all strike a compromise? Because otherwise what we're going to end up with is either a terribly unsound plan being passed or a terribly unsound plan being failed. The only middle ground we have is to collectively agree on some type of solution or compromise. And if there are reasonable alternatives, as in counting numbers already produced or looking at new settlements or just shifting the numbers over a little bit so that maybe now we're not looking at all of the sites within the Greenbelt having to be used. Perhaps some of that need could be met from Central Bed's new settlement. It's not like it doesn't link into work they've already done. So that's generally the gist of what I want to do. It's really nebulous. I think I prefer to stick to the planning, the structure in the PPG as closely as possible, because I think after all it's been put there for a reason. And I don't agree it to be planning decision because it's too subjective. We have got a list of instructions that should have been followed, and there's no reason not to follow them because they're going to have to do it in the review anyway. And it also affects 5-year land supply. To have a big pot of land sites is a really good thing for the future. It's going to serve them well into the future. So there's no reason to leave it undone. That's my feeling. Thank you a lot.
Thank you. Mr. Watts.
Yes, thank you, sir. I wanted to respond to a point made by Roland Bolton regarding the need to have some certainty as part of whatever local plan emerges. I agree with him that we don't want a position where there's a black hole where nothing is seen to be done or planned, or where there are no sites coming forward until 15 years' time. But that conflicts quite easily with the need to provide new infrastructure, to deliver new infrastructure, where settlements like Codicot and others have a clear deficit currently. What we can't have are greenbelt sites which would literally impose nearly 400 odd houses on a settlement like Codicot, being brought forward in the short term when there is no infrastructure delivery. Now, this should have been a key component of any assessment of site selections on greenbelt sites and appropriate weighting given where that deficit has clearly been identified. And it's not as if the council didn't know, for example, that in Codicot there's a clear need to provide expanded school facilities around the existing school and provide them, not just have planning permission. So, for example, in the Schlar in 2016, on the reference sheets, there is clear reference to the need for village schools to be expanded. It's not just a question of giving them planning permission, it's got to be provided on the ground before other sites in the Greenbelt around Codicot can be brought forward and delivered. So the delivery of infrastructure, where there is a key issue of capacity deficit, should have been included in the site selection process and in the Greenbelt review. Mr. Goatley made a second point, and again, I would agree with him. There's part of that selection of sites in the Greenbelt and the way you weight them and give priority to some and not to others, the impact of the quantum of new housing around a settlement in the Greenbelt is also an important component of that assessment. So there's a strategic approach to the weighting of objectives, which I believe the council should have given more weight to. So they're the 2 points I would make over and above what I've already said, sir. Thank you.
Thank you. Mr. Egg.
Thank you. Talking about the approach of the council, I'd like to reference paper B, point 3, which the council says up front, they're going to seek to maximise, they say reasonably maximise the level of housing. They've had ample opportunity to reflect upon the level of housing, and they have not taken that opportunity to reduce the level of housing they would like to see built. That's the first point. And then in paragraph 4, which relates to exceptional circumstances, the first 3 of the points they raise relate to acute housing. And that's something that will be resolved when the final number on the OAN is determined. The 4th point talks about constrained development would have an adverse effect on social economic objectives pertaining to the housing crisis in North Herts. Well, given that inward migration accounts for some 60% of development, I really question whether there's a housing crisis in North Herts. And lastly, on the 5th point, the strategic sites have been allocated in accordance with MPF 52. Part of MPF 52 speaks of working with the support of their communities in the allocation of these sites. And the reality is there has been no support for these sites, and there's been no cooperation or discussion with the individual communities about the allocation of these sites. Thank you very much.
Thank you. Mr. Bolton.
Yes, just very quickly, you're being asked to look at the site selection process, if you like, and use it in reverse, if you like, to deselect sites. I would suggest that that is not necessarily your first step when dealing with the soundness of this plan. As we've highlighted before to you, the 2012 NPPF paragraph 47 requires a plan to identify sites for housing for the period 11 years to 15 years from the date of adoption, if possible. It is clear that you have before you sites, maybe additional sites, that depending on where you decide the OAN is. So therefore, your first point of call should not be what sites can I delete in order to reduce the supply to meet the OAN for shorter plan period, but it should be, should I be considering a plan that fully meets the requirements of the NPPF in terms of the plan period? And therefore, that I think is your first consideration if you do come to the conclusion that you have a surfeit of sites. We set out for a number of reasons why we don't think so. And again, the suggestion that you can use the site selection process to deselect sites has to be approached with caution, because part of the selection of sites is about selecting sites that can deliver, if like early in the plan period. And you have submissions to you from those involved in promoting sites that a number of sites can deliver faster than is being currently suggested. So that is another point you need to take into account if you were to use the site selection process as a means of deselecting sites, which I would not recommend that you do for the reasons I've set out. I was tempted to give you a benefit of our extensive experience in Aylesbury Vale planning, in Aylesbury Vale and Central Bedfordshire, and how they reached their or in case of Central Bedford, a similar impasse to this plan. However, just a passing thought, our submissions to the Central Bedfordshire plan is that the allocations currently within that plan, including those around Luton, are not sufficient to jointly meet the needs of Luton and Central Bedfordshire, especially within the Central Bedfordshire, or sorry, especially within the Luton housing market area. So there are, if like, still different views on how well Central Bedfordshire is actually coping with meeting its own needs and those of Luton's, and that is still out for judgment. And I do not suggest that we reopen or attempt to run Central Bed's examination here, and we have the pleasure of doing that in a few weeks' time. Thank you.
Thank you. Mr. Dorman.
Thank you, Mr. Barclay. I've got three very quick points on reasonableness and then something on adequately robust in relation to question 23(1)(b). And my comments relate solely to the east of Luton sites, as you won't be surprised to hear. Obviously, in the east of Luton, the sole purpose for the houses proposed there is to meet the so-called unmet housing need from Luton. But as we have demonstrated in previous matters, such is the scale of the house building programme in Luton that there really isn't a realistic unmet need from Luton. And if there was, it would first of all have to be appropriated towards, or pointed towards Central Bedfordshire to take on. So I don't think, well, NHDC has taken no notice whatsoever of this fundamentally important point. The actuality of house building in Luton Thus, I declare their approach has not been reasonable. There's also the question, I suggest, of having reassessed the Greenbelt land to the east of Luton as now making a significant contribution to the purposes of the Greenbelt, as opposed to the previously wrong modest contribution. Whether NHDC has been reasonable in continuing to make the case for this extra protected area to still be regarded as suitable development to meet a need that doesn't exist. I believe you have stated in one of your comments earlier that the bar in this area has been raised higher by this reclassification to significant. And yet NHDC does not seem to care about this and plows on regardless. This is not a reasonable approach to take, particularly since there's no evidence that NHDC has even considered, let alone analysed, the scale of house building in Luton. My third point on reasonableness is, at no stage of this examination has there been any inkling, to my mind, of a reasonable approach taken by NHDC in terms of trying to do the best for the environment and the quality of life of its residents in the threatened villages of Cockenhoe, Mangrove Green and Tea Green in the east of Luton area. And this is a council, remember, that with the current political makeup of the council, when they came to power, I guess a year or so ago, declared the area as a climate emergency. I can suggest no other explanation for their course of action in regards to building houses in this area other than to benefit from the new homes bonus, the Section 106 infrastructure payments, and the continued council tax receipts that will result from the building of these unnecessary houses. In terms of adequately robust, there's one point that has not been mentioned, which I think is becoming very important to me, and that's education. And Mr. Watts mentioned education in relation to another site, it was Codicott. And this is pretty critical in terms of the east of Luton site. First of all, the point here is that Herts County Council has insisted that secondary schooling on this site has to be self-sufficient and that it cannot sanction capital expenditure for secondary school provision unless the full allocation of housing is built. This gets interesting because previous applications were for smaller parcels, not all of the parcels together. But Herts County Council insisted that such is the level of school need in North Hertfordshire, that therefore the whole allocation had to be built together. NHDC agreed with this as recently as November 2019 in ED 173, paper C, paragraph 3, where they say, quote, "It is finally worth re-emphasising that a key influence on the scale of the proposed allocation east of Luton is the requirement for it to be self-sustaining in terms of education provision. This point has already been explained at length to the examination. In NHDC's view, the contribution that this authority makes to Luton's unmet needs will be 1950 homes, or it will be nothing." Several points arise from this. Now, with the delay in proposed building by 2031 of only up to 1,400 homes in this area, with the balance presumably following after the planned period, this means presumably that the smaller housing total still has to pass what I call the test of the Herts County Council secondary school viability, if I can put it that way. Whether the fact that the build out of the remaining 700 homes beyond 2031 will be acceptable to Herts County Council remains to be seen. When you look at the revised trajectory of builds supplied by White Peak Planning or Bloor Homes, it shows a quicker delivery of homes than that in the NHDC trajectory. It's some 70 to 75 homes a year higher. Whether that's achievable is anyone's guess. The original statement of common ground signed between NHDC and Bloor Homes had a total build period of 16 years for the east of Luton sites, whereas White Peak's analysis shows this is now 12 years. So I'm going to take the Bloor Homes quicker trajectory. And this shows that the first delivery is expected in 2022-23 with 100 homes, and thereafter 205 a year through to the end of the planned period. The statement of common ground signed between North Herts Bloor Homes and the Crown Estate in November 2017 said that the primary element of the all-through school will, quote, will commence in phase 1, approximately 3 years from commencement of development. So the primary school will start building in 2025-26, and I'm taking a guess that it'll take about a year to complete and commission, so that'll be 2026-27. By that time, according to the Bloor trajectory, 920 homes will have been completed. And in the first 4 years of the development, there would have been 715 completed. So the assumption must be that all the people living in these 715 homes from the inception of the site through to when the primary school opens 4 years later will either be single or childless parents, or that they have all moved from close nearby, say 5 miles maximum, if they have children of primary school age, and thus who are already enrolled at a primary school either in Luton or some of the nearby towns in North Herts, or indeed Harpenden in St Albans district. I submit those are very bold assumptions to make. Any family moving to the development from further afield, we've heard of possibilities of people coming from London for commuting, or from wider Hertfordshire or Bedfordshire, they are going to find it very difficult to find primary school education for their children. White Peak planning made much of the fact that the majority of dwellings, 66% I think it is, proposed for the east of Luton side are 3 and 4 bed homes. The houses being built must be to accommodate families, so that from the start of the build, the assumption must be that there will be school-age children living here. Now, the forecast pupil demand from the Herts County Council, this is contained in Appendix B of ED 104 of February 2018, seems to show that the anticipated pupil yield from the east of Luton sites in the first 4 years, and there's no, this says for all pupils, there's no distinction between primary and secondary schools, is 0.1 of a form of entry in the first year, 0.2 in the second, 0.4 in the third, and 0.5 in the fourth. One form of entry equates to 30 children, I believe. So this suggests there'll be 3 pupils in the first year, an additional 6 in the second year, 12 in the third, and 15 in the fourth. But with 715 homes having been completed, and one assumes sold by that time, and I'm taking some projections here, some hypotheses just to make the point. If only a third of those households have children of primary school age, that's 240, and of those only a quarter, say, have moved to the area from further afield, that could well mean some 60 children having to find primary school places. The excellent little primary school that we have in Cockenhill will not be able to cope with that sort of number. And it is apparent that all the schools in Harpenden and Hitchin are full, according to Herts County Council, hence the requirement for the site to be self-sustaining. Herts County Council also reported that Luton stated all its schools are full. Now, if in addition, any of those 715 households who have moved into the area from further afield also have children of secondary school age, then education for them is going to be extremely difficult, because the statement of common ground states that the secondary school provision on the east of Luton sites will be, quote, built out to meet the pupil yield requirement as they arise through the development. In other words, there will be no secondary school provision on the site until probably well later into the decade, because the assumption in the statement of common ground surely is that the site is designed to accommodate new children of primary school age, and then as those children grow to secondary school age, so the secondary school provision will be built to accommodate them. So woe betide any family with secondary school age children who move there from further afield, as there seems to be no schooling available for many years because all the schools are full.
Mr. Dorman, yeah, I understand the point. What I'm struggling with a little is how this links to the Greenbelt review work and the site selection process. If you could help me out on that, I'd be grateful.
Yeah, the reason why I didn't speak much earlier is I really did wonder whether this, what I think is an important point, was going to be relevant. And thank you for giving me the opportunity to raise it. I suppose my statement would be that building these homes here in the Greenbelt, which I believe to be an unnecessary build of these homes, means that schooling has to be provided. I don't think schooling is going to be provided anywhere near to the extent that it will be required to meet the demands of the people living there. And therefore, I don't think that that means that this aspect has been thought through carefully. I think it's a significant problem that's been overlooked, and therefore it is not adequately robust. I think I'll leave it there, if I may. Thank you very much.
Thank you for that, Mr. Dorman. Mr. Hawkins.
Thank you, Inspector. I'd like to say that I've heard some really pertinent points this morning from fellow objectors, and in the past we've often been referred to as greenbelters, and it now appears that we're taking rum whilst we're making decisions about the future of our local area. Obviously, I object to both of those suggestions because we are the people, we live in this particular area, we are the ones that are subjected to all the problems that come as a result of a local plan. And on the basis that I live in a democracy and I am able to express myself accordingly, I see this particular exercise as a very worthwhile exercise, given the fact that it has the support of government in the way that it actually wants local plans to be derived. And by that, I mention the fact that a very good friend of mine, Peter Lilly, Right Honourable Peter Lilly, MP for Hitchin and Harpenden, as he was at the time, he's now Lord Lilly of Offaly. He very kindly engaged me with the Housing Minister in 2014 with regard to how we assess the fair approach to developing a local plan. And he sent us a letter which basically states that the government continues to attach great importance to Greenbelt as a way of preventing urban sprawl. Greenbelts are created not by central government, but by local authorities who protect them, in line with national policy set out in the National Planning Policy Framework. The framework makes clear that inappropriate development, including most forms of new building, should not be approved in Greenbelt except in very special circumstances. So I guess we've probably spent the morning trying to assess whether or not there has been a reasonable judgment on building in the Greenbelt, and that the consumption, the level of Greenbelt that's going to be used is considered to be fair. I think I've made the point before that 85% of the developments are going to be made in the Greenbelt, and therefore I'm finding it very difficult to understand how the local authority is protecting the Greenbelt at the same time as consuming it. I guess it's the dichotomy that they're placed with. He goes on to say that, however, in October 2014, we issued additional guidance to remind local authorities that in planning to meet local housing and other needs, they must have regard to policies in the framework on the protection of areas such as Greenbelt, which indicate that development should be restricted. So from this sort of correspondence, I'm reading from the people who are the lawmakers and the people that we are following their concept of right now, that, you know, basically we should be building as little as possible in areas that are subjected to greenbelt protection. Because after all said and done, what is protection if it's not there to provide a break on this type of development being undertaken? I then got access to a letter that he issued in 2015 to all of his colleagues in government. And it says the government has put in place the strongest protections for the greenbelt. And then he goes on to say, the Housing and Planning Act 2016 has increased local people's power to plan their areas with new measures to speed up and simplify neighbourhood planning. You know, I've spent 5-6 years of my life working with many people in my locality, creating a neighbourhood plan. We've even taken it to a referendum. But no one at North Herts District Council has ever come to us as the body that was empowered at that point in time to create the plan to discuss the relevance of what they're trying to get across right now for my area, Little Wymondley. And I'm sure that's the same experience, having spoken to hundreds of people across North Herts, that others have experienced too, Codica, Ickleford, Nebworth. And we're all a little bit incredulous as to what we're supposed to be accepting as the right way forward. And, you know, I can only say that we're greatly appreciative for the moment like today to express ourselves, but there seems to be a huge dichotomy in the approach. If North Herts District Council are here to protect the land of the Greenbelt and at the same time wish to consume it, we really are struggling to understand why. And given the fact that local politicians have been saying for many years that the government has forced us into creating this huge plan, and given the circumstances now that the numbers are falling, again, there seems to be a dichotomy in the expression of who's being forced to do what, and why are we clinging on to the numbers that we appear to be clinging on to. So that's my, that's the question I'd like to pose. Why are we trying to assess a plan that has clearly got a need for a reduction of housing numbers? And if there is a reduction in housing numbers, why isn't there a reduction in sites too? And the growth villages specifically are the ones that seem to be being used incorrectly at this stage. So thank you for listening to me. Thank you very much.
Thank you, Mr. Hawkins. Mr. Williams.
So thank you very much. It was only to ask you in relation to the points that Mr. Dorman was making recently, whether you required from us any further assistance. I think our position is that this is self-evidently a development control issue. We know that you already have statements of common ground and evidence before you. I can confirm, it will come as no surprise, that my clients have an ongoing discussion and indeed a settled position with the Education Authority, and indeed have had discussions with Cock&Hoe School as well. The land and the finance can be provided as early as is required. That is one of the advantages of the site, that it has no such impediment. But Mr. White is here if you want any further detail, or we can provide a note, but it may be you feel you have enough information in any event.
I think that I have enough on that. Thank you, though, Mr. Williams.
Thank you, sir.
Ms. Cotier.
Thank you.
Apologies. What I'm going to do now, because I think we are getting to the natural end on this particular point. So if I can hear from Ms. Cottier and then from Ms. Hamilton afterwards, and then I'll hear from the council before we take our lunch break, unless Mr. Smith would like the benefit of the lunch break to go through the points that have been raised and list them and work out precisely what reply he wants to make. But I'll maybe ask him that at the time. Let's see where we get to shortly. So Ms. Cottier, first of all.
Thank you. So there's the problem of the visual impact and the issue of openness not having been properly applied to the East of Luton site. Ms. Ormsby said that the first review dealt with openness and then visual impact was added to the second. So why is it that in terms of its total visual impact, the fact that the site lies next to major development in the field next door, which we already discussed had boundary issues within, or boundary, more than issues, boundary overlap within the site's EL1. It bleeds into, it doesn't just touch the edge of the site, it bleeds into the site. In other words, it joins to it, it touches it, it blends into it.
I remember your description from last week.
The description, yes, and the map.
I remember you describing that last week, yeah.
Yeah, and have you received the map that I sent in response to your request?
I haven't as yet, no.
Oh, I sent that last night, so.
Right. Okay. If you sent that last night, it won't have reached me last night because I can't get email, unfortunately, where I'm staying.
Okay. Well, you've got the pictures in there, the maps that you requested with the labels and the source references in there, and so I retrieved the construction and scoping maps for the development for all phases. And it was even worse when I looked at those maps. They were even more detailed, but worse than the ones I actually originally knew about, because the original ones that I knew about showed an overlap into site EL1, which I think is an openness issue in as much as it bleeds into the site, and thus there is no space left between them at all, thus creating a solid wall to wall around the whole East of Luton boundary will be taken up with development. There will be no openness. And the visual impact, one can only imagine how that is going to change. And it is a very sensitive setting because it's the OAMB setting. So yeah, so that's that part. And the other issue was that when I was looking at the construction report, I came across health hazards, many of them. Now, the site, the risk hazard area was given as 250 metre radius. And so we're looking at really the entirety of the EL1 and 2 Blue Home site was included in their risk assessments. And they were very good, high standard risk assessments, I would say, and they covered issues that we can only dream of having been covered in these risk assessment, in these environmental impact assessments that have been put forward in this plan. They're nowhere near as detailed, and neither are the habitat assessments. But these guys know what they're doing, and they really do look at things in detail. And I was alarmed to find out that there was a very high risk of methane risks beneath the soil. There was radioactive particulates, moderate to low to moderate risk. There was very high risk of unexploded ordnance in the landfill site, and there was also there was high risk of asbestos particles, and there was high risk of methane buildup in houses. and surrounding residential areas. And this construction site that we're discussing in this housing is closer to this location than any of the existing houses, which are at least a certain space away from it. The Bloor Homes EL1 and 2 sites, as I've said already, are overlapping into this construction site. So the map that I was asked to provide, I did provide, and it is labelled very clearly. And it appears that on a larger than I initially thought corner of EL1, there is to be what is going to be landscaping works. And initially you would think landscaping must be like, I don't know, trees, maybe some hedgerow, perhaps, that type of thing. But when you read the report, it's very clear it's earthworks, and earthworks involving soil taken out from the contaminated landfill that they're excavating before they can do any of the approved development. Now, bear in mind, we're not talking about the future Luton Airport expansion development. We're talking about the already approved major development, and before that's already been approved and it's due to go ahead, but it's already been partially started. Some of the associated works have already been started, but the part that is going to go ahead on the park, that excavation work has to take place first because it involves the foundations, and there's certain piling they're going to be driving piles down into the soil, but they're also going to have to be excavating, I think, nearly 500,000 meter squares of stuff from the contaminated landfill underneath. And that's where they had to do an extremely detailed risk assessment because of the emissions that are going to come up from the soil. And then the soil that gets dug up, or they have to sort through it. I actually had a conversation with a woman who was in charge of the earthworks and the groundworks, and she was explaining. I said, well, what about all the stuff that's going to come up from the landfill beneath, and people living in the area? And she said, well, we're going to do our best to partition it off. However, obviously there is a degree of risk, and we've detailed that in the risk assessment. So having looked at the risk assessments, they are going to dig up the soil, sort through it. They're going to, some of the stuff can be sent away, but some of it is going to be used as hardcore, and it has to be stored in certain areas. And I think the landscaping on the corner of EL3 appears to be one of the areas where the soil that's dug up is going to be like piled up and then sort of spread around behind the site, which lies parallel to the whole of EL1 and 2, to level it off so that they can put a temporary replacement park on it. But then in phase 3, change that temporary replacement park into the long stay car park. And I had a conversation with Lucy Murphy in the Chiltern Conservation Board. She was the first one that told me, oh, did you realise that replacement park is actually only temporarily going to be a replacement park? It's going to become the long stay car park. So that essentially means, at that area at least, there is no openness. And it also means visual impact, just buildings. And then joining on to that, we're proposing these houses, schools, retail centre. We can safely say openness is non-existent. So if they were assessing in the first review openness, when they knew this development was being considered at that point, and we know they knew because I produced a letter from NHDC last session, and I quoted Councillor David Levitt saying that there were issues, landscape issues, and there needed to be a visual assessment done. There hadn't been. We know there are issues, in his own words, it comes from him. So that is a major concern because of the sensitive setting, as well as the function of the greenbelt from the perspective of the people living in the area already. And then as far as the visual impact goes, that in the more recent study, we definitely by then knew this development was happening and it wasn't a thing of the future. That hasn't been factored in at all. So I can only conclude that no, it has not been an adequately robust approach. But worse than that, the approach that the minimal approach that they are applying, that hasn't even been applied in the case of east of Luton. That's been left out completely, and I am absolutely stunned and amazed at how such a huge development could have been left out of a greenbelt review when it is on the greenbelt land, and even within the site that's being proposed. And I have provided, I hope, what you will find to be more than substantial evidence, and I have given lots of further links, because I make the point that there are numerous interconnected projects that are overlapping at more than one point. So it is important that you may need to go and read this, the construction report to understand the map that I have provided, because they have mapped out in a red area the DCO boundary, but within the DCO application, there are all the other developments previous that are considered associated development, supporting the DCO, but not subject to the passing of the DCO. I mean, they've created a really complex planning web here, and I have challenged that the enterprise zone development is not actually major development, but it is a nationally significant infrastructure project in and of itself. And even the Department of Transport, when they responded to that major development application, also said that they were concerned it was a nationally significant infrastructure project in and of itself. And so I wasn't the only one to point that out. They also pointed that out. So if that be the case, that is huge. And how it's airport related, highway related, and there's a pipeline. So it's energy related as well. There's three reasons why it should be significant, nationally significant infrastructure under the Planning Act and part of the DCO. And if it had have been, then a strategic environmental impact assessment would have covered the issues of the greenbelt within it. But as that was never undertaken, because it was only passed by themselves under town and country planning as a mere major development, when it really isn't a mere major development, that's all missing too. But luckily, what we do have at least to go on is some of the excellent scoping reports that they paid a lot of money to have. I think it's ACOM produced them, most of them. And they've done a really good job, and they're really worth reading, because the information in there, it needs to be looked at, because there's no way. Oh, Japanese hogweed. There's Japanese hogweed. Is it Japanese hogweed? Yeah. Japanese hogweed is in the site next door as well. So they're going to be excavating a part that contains these Japanese hogweed, knotweed, is it Japanese knotweed or something? That really dangerous plant that grows everywhere. They're going to dig that up and they're going to put that in other places. So it might spread the spores. And then the last thing Bloor Homes, I would have thought, wants to dig foundations only to find that Japanese hogweeds got knotweeds gotten in. They're that detailed. They're really good. Those reports need to be looked at, and they contain all the maps. I provided screenshots. I couldn't extract just the page because I don't have that facility on my Adobe, but I'm sure that the people at your the planning team does have that. They can extract the map out and enlarge it. But have a look at that, because there is no way that openness is even going to be, it's going to be a distant memory. No,
Okay, Thank you. Is there anything else from you, Ms. Cotier, on this point? Because I'm not going to come back to you on this one before going on to question C, which is about the sustainability appraisal.
No, I mean, there's always more you can say. I mean, it's endless, you know, but for now, I think, you know, we'll cap it here, and I'll put to rest anything I haven't said.
Thanks for that. Thank you. Mr. Williams.
So thank you very much, sir. It was only to remind you, not that it's necessary, that we undertook to provide you with plans to assist your understanding in relation to the points raised by Ms. Cotier last week.
We're going to get some plans from Ms. Cotier and from yourself too.
Yes, and we haven't seen the plans to which Ms. Cotier referred, but we'll contact the programme officer to get those. Ms. Cotier has sort of added some points today, and we will see whether the currently anticipated plans assist you in relation to those as well. But those are in hand, so suffice it to say we don't agree with a great deal of what Ms. Cotier has told you.
Yes, I don't necessarily expect people to agree.
No, sir.
Thank you. Okay, I'll hear then from Ms. Hamilton, Mr. Dorman, and then I'm going to draw a line with Mr. Dorman speaking last. I'm then going to take a break for lunch and then come back to hear the council's reply, then move on to question C about the sustainability appraisal. So, Ms. Hamilton.
Hello, I think I can do some of my points into 23.2 tomorrow, but I would just like to say in response to Mr. Bolton, yes, of course, developers are going to be like, yes, everything's robust, everything's reasonable. Of course, that's what you're there for. That's what you want to do. You're the one building the houses. We're the one fighting for communities. So with that in line, I'd just like to say, like, firstly, I thought CBC was actually reducing some numbers in regards to their plan, particularly on one of their sites north of Luton. So I don't think we should be too hasty in, oh yes, these can't take on other people's needs, etc., etc. I am in agreement with Mr. Hawkins. You know, going back to that point that I made earlier about like, you know, healthy communities and protecting reasonable resources land for us. You know, it just seems to be we're just digging our heels in and going gung-ho with this. You know, we've had higher variations, not in line with this, Greenbelt reviews, we're not taking on Calverton judgments, Guildford judgments, and all this malarkey. You know, we seem to be losing a lot of our benefits, and I don't think we're going to be, any of us are going to be gaining anything. Our communities are not actually going to be gaining anything. I'll go into that more in your site selection, which I think is C, maybe, I think. But I would like to point out that, you know, in relation to what Mr. Hawkins said, I think a number of us in communities have tried to do things. I know in Great Ashby, we looked at trying to apply for like a community asset based on the GA2 site. But, you know, we at that point in time, which was what seemed like 100 years ago, didn't even know there was a proposed development on it. So that was like poo-pooed straight away. But in relation to what he did say, you know, we did offer to meet with NHDC previously. We offered to meet with NHDC so that we could highlight the issues with the particular site, obviously, and they didn't take us up on that. Whereas taking Broxbourne as an example, now Broxbourne have handled things totally different. They had all of their, they had like everything available that they had was there right from the start, transparent for everyone to see. And like Broxbourne did seem to listen to different communities. They listened to the experienced like groups such as the Heritage Group. They met with the Heritage Group. They listened to the people that know what they're talking about, i.e. the Badger Group. They met with us on that as well. And they dealt with their plan accordingly and responded accordingly. And I do believe that's even been approved now. So, you know, with regards to the process, as well as not really looking at SHARS, not reassessing critical situations and assessments and sites, and looking into responses that they have received in line with the GBIU, I do think that they could have taken on board other things within this process that might have alleviated the situation and allowed us to move on. Yeah, I'll bring that more up in the actual thing later. Okay, thank you very much. Thanks.
Thank you, Ms Hamilton, and yes, well done for the best use of the term malarkey so far this morning. Mr Dorman.
Thank you, Mr Buckley. I'll be as brief as I can. Just a few points about adequately robust again in relation to your question. There are inconsistencies, I believe, in the approach taken by NHDC in reference to the east of Luton area. For example, in its paper B tabulation of ED 172, page 8, they point out that another parcel of land to the east of Luton, which was SHLA reference 341, was ruled out for building by, quote, virtue of sensitivities relating to landscape topography, historic environment, and AONB setting. Now, this parcel of land lies just to the north of the threatened sites.
My apologies.
Two of the reasons cited.
Mr Dorman, sorry. I think you said, did you, that it was SHLA reference 341? Was that right?
Yes, that's right. Yes.
Thank you.
Yes, it's just the north of the proposed site. Two of the reasons cited by NHDC are correct, namely that site abuts closely to an AONB, and also by virtue of the protected status of Puttridge, Bury, House and Land. However, the other reason given is spurious, because sensitivities to landscape and topography are exactly the same as for the threatened east of Luton sites just a bit to the south. In fact, I would argue they are stronger in the threatened area, as the land around Cockenhoe is much more open than it is to the immediate north. This tabulation also shows that reference 341 land would be, quote, detached from the Luton urban area. Now, this area is no more or less detached from Luton than the threatened sites. Area 341 is to the east of Selsey Drive in Luton and abuts school playing fields with a footpath linking it to Mangrove Green, where I live. In our threatened area, our sites abut the Luton Wigmore estate with open agricultural land leading uphill towards Cockenhoe or towards Tea Green. In essence, apart from the correct historical and AONB aspects, there is in reality little difference in the layout of the land and its proximity to Luton. So there doesn't seem to be a great deal of consistency in the approach taken by NHD in relation to this east of Luton area in Greenbelt terms. Another reason they give is that it checks the unrestricted sprawl of large built-up areas, which has to mean Luton. And therefore, if that reason can be applied to this area 341 and not to the threatened area east of Luton sites no more than half a mile to the south, frankly, that beggars belief. And a final reason they give is that area 341 assists in safeguarding the countryside from encroachment, which is exactly the same as the threatened east of Luton sites. So the same criteria being used are not being applied in the same way, and therefore I submit they're not adequately robust. Also, another point about robustness, in their response, NHD has made the point that some of the sites across North Herts that were beyond the Greenbelt were considered either as less sustainable locations for development and or would result in the council's view in disproportionate levels of housing in a single village. How can they justify that statement when compared with the proposed development for the east of Luton sites on protected and significant Greenbelt land, which will engulf 3 villages, 200 houses in total, with a hugely disproportionate level of 2,100 houses, which is nearly a 90% increase, and to meet a supposed unmet housing need that we have proved doesn't exist. And then the final point, they say that the east of Luton site will provide opportunities for social infrastructure with a wider public benefit. And this includes low-level retail, despite the fact that less than half a mile away is the Wigmore retail area with its Asda and Iceland supermarkets and other small outlets and eateries. Just what retail provision is believed by NHDC will survive in today's harsh retail climate with strong, well-established competition already in place locally? That cannot be a robust reason for development. I think that's it. Thank you very much.
Thank you for that, Mr. Dorman. Okay, I am going to break for lunch now. As I said, on our return, I'll hear the council's reply to the points that we've been hearing, and I will then go directly from that to issue 23.1C, and that is about the sustainability appraisal. So if I can remind everyone for the break, unless Mrs. St. John Howe jumps in very quickly and tells me that I've got this wrong.
Did you, sorry to interrupt, Simon, if everyone's on the afternoon meeting, they can stay on the Zoom call.
Right, okay, fine.
If there's no change to the participants, you can keep the call open and I can end the stream and restart it when everyone comes back.
Have you changed the rules deliberately, just so that I've got it wrong?
No, it depends. If there's different people, then we change it. If not, we keep it the same.
Okay, thank you for that, Mr. Franklin. So I think we all heard Mr. Franklin there. If we ignore what I was about to say and instead simply turn off our what do you call it? Cameras. Thank you, cameras and microphones. I now make it 1 minute past 1. I adjourn the hearing to resume at 2 o'clock. Thank you.